the division bench with a direction to the trial court that two issues were there. First, there were three persons. One claimed to be juvenile claim. So the learned honorable division bench referred the matter to the remanded back the matter, is saying that you first decide the juvenility of the person. If he is juvenile, you segregate, and if not, then you proceed. And proceed from which stage, my lord? Proceed from the 313 stage with respect to putting incriminating questions, circumstances which have turned up in the evidence of PW 1, 2, 4, and 6. Against the PW 1, who have been examined by the prosecution witness 1, 2, 4, and 6. Those incriminating questions were not put to me in the earlier. So with that stage, the matter was remanded back. After that, what happened, my lord? When the juvenility was been decided, the trial got separated and our proceeding started. Now your lordship will, my lord will see.
Now, was he found to be a juvenile?
One was found to be juvenile, my lord.
So out of 3 accused, it was reduced to 2.
Two. Now what happened, my lord? After
Now, wait a minute. The first judgment and order
yes, my lord.
was passed when?
It was passed 5/12/2012.
5/12/2012. Which page is it?
My lord, it is not in this record. I have.
Or it is not here?
It is not there. But I have given the judgment before.
Okay. Then where is the judgment passed by this court in the appeal, criminal appeal? What is the criminal appeal?
No, my lord. Criminal appeal judgment was 5/12/2012.
Acha, what about the trial court judgment?
Trial court judgment, though it is still that judgment is also not there on this record. My lord, may kindly see, given these 2 copies.
So when is the trial court judgment?
The present impugned judgment is, my lord, of 12/6/2015.
No, please. We are asking you, we didn't ask you about the present
2007.
date,
Date is of 27/2/2017. 2007.
27/2/2007.
Yes, my lord.
So this was put to challenge. Out here convicted 3 persons
My lord.
under 30234,
My lord.
all 3.
All 3.
So thereafter, they went to High Court, and what is the High Court criminal appeal number?
High Court Criminal Appeal 76/2007.
This was disposed of in 2012,
This was disposed of 2012.
wherein remanded back to determine
Determine the plea of juvenility
taken by whom? Taken by what is his name?
Pranav Das.
Pranav Das. Found to be juvenile.
He was found to be juvenile.
And case to proceed
From 330.
on the stage of 330.
On the stage of 330 by putting the incriminating evidences which have surfaced in the evidence of PW 1, 2, 4, and 6.
Incriminating evidence which were found in the evidence of
PW 1, 2, 4,
2, 4,
and 6.
only 4.
No, my lord. PW 1, 2, 3, 4, and 6.
1, 2, 3, 4, and 6.
My lord, may kindly come to para 11 of that High Court judgment. I have given a copy. Para 11.
Yes.
In the case in hand, my lord, in the case in hand, none of the incriminating circumstances contained in the evidence of PW 1, 2, 3, 4, and 6 has been laid with the appellants so as to elicit their explanation with regards thereto. Having regard to the testimony of these witnesses, There is no manner of doubt that this omission on the part of the learned trial court in examining the appeal ends under section 313 CRPC has resulted in great prejudice to them.
No, no, they see. No, don't do, where is the, wait. Put on down there. But the commission. Yes. Yes.
In the above view of this matter, we are not inclined in the facts and circumstances of the case to sustain the pleas raised on behalf of the respondent state. As a corollary, the impugned judgment and order cannot be sustained and is thus interfered with. The appeal is allowed. The case as a consequence stands remanded to the court of the learned district and session judge Golagat. The learned court below would at the first instant examine the tenability or otherwise of the claim of juvenility of the appellant Sri Pranab Jyoti Das in terms of the act and the rules framed thereunder and record a finding with regard thereto. In case Sri Pranab Jyoti Das is held not to be a juvenile on the date of the occurrence, the learned trial court would proceed with the trial of the session's case from the state of examination of the appellants under section 313 CRPC and render his decision on merit. So, my lord, in pursuance to this judgment, remanding back, the learned trial court found that the juvenility plea is genuine one, my lord. It was being segregated, and with me, with the other two who are before your lord,
Yeah.
other two who are before your lord, the trial, the 313 from the 313 stage, it was supposed to proceed. Now, your lordship will kindly
Trial court judgment was passed when?
trial court judgment, the present impugned judgment is of 12/6/2015.
Yeah.
My lord. And the reason why I'm trying to refer those the chronology of events, because your lordship, what happened when the day the judgment was being passed before the impugned judgment, on that very day, 313 was recorded. Yes, my lord. I believe my lord was hearing that matter earlier.
Okay.
My lord, kindly come to the order of 12/6/2015.
Okay.
12/6/2000. It is not, it's in part of the LCR.
This is just.
Page 67.
No, that is the judgment you are talking about.
That's the judgment.
That is the judgment. No, it is an order.
No, let us see the 313 statement made here. Which page is it? It's the paper book. Page 39.
Paper book, your lordship, there are two sets of 339, 313.
Whatever it is,
My
let us see one by one.
39, page number 39. My lord is there.
Yes.
The lordship will kindly see, or aged about 40 years taken before see session just Golagat on the 12th day of June 2015. And your lordship, my lord will kindly come to the page number, page 67, 67 of the paper book. My lord is there.
Yeah.
The lordship will find at the footnote at the bottom of the page, date of judgment is of 12/6/2015.
Lordship, my pages do not tally with.
Paper book.
It's a big book.
Paper book.
Whatever has been provided by my office, page 67, something else.
First page of judgment.
You'll be referring the page number, so I'll be
No.
following that only.
I don't know.
My page 67 is.
My,
different.
I cannot blame. Your lordship is there.
Let us see the report, the LC. Let's see. Let us see the main judgment. P1 is on 12/6, that is there. Date of judgment is
12/6/2015. And Madam, there is a specific order also. There is a specific order, I believe, on the last occasion, my lord has seen them. From the LCR.
What is the order sheet? This is the order sheet.
My lord, it should be with the, in the LCR.
No, no, it is. But I'm trying to see what, there's no order in between.
My lord, there is an order of 12/6/2015.
Ha.
If I may, I read it.
Yes.
Accused Probita Das and Mintu Das are present.
Ah.
The record reveals
Ah.
that though both the accused are examined under section 313 CRPC on 25th April 2014 by my learned predecessor, yet the forms same are found not available on the record. So they are examined again under section 313 CRPC on today, and the forms are enclosed with this record. The accused have already adduced evidence in defense. We have already heard arguments of learned advocate of both sides. Judgment is prepared and pronounced in the open court, and the same is enclosed with the record. What the reason for referring to this order is that your lordship will, if your lordship sees that the trial before a court of session, it starts from the state of opening of the case by the prosecution. Then you go with the framing of charge, whether you frame the charge, if it is acquitted, discharged, that's a different thing. Otherwise, the trial proceeds. So once the prosecution evidence is raised, then the 313 comes into play. After 313, a question is put to the accused that whether you want to adduce evidence or not in your evidence. If he says no, then the arguments have been heard on the basis of the evidences and referred to the 313 because it is a duty bound by the trial court. And after that, you record the judgment. You pass the judgment. Now, if your lordship will see page 67 of the impugned of the paper book, your lordship. My lord is there, page 67. I believe it will be page 63 in your.
No, 67.
Yes, my lord. No, I'm just aiding my friend. Page 67. Your lordship will see the date of evidence commenced from 19/7/2004, culminated on 18th August 2006. Now, date of argument, your lordship, 25/2015 means 20 May 2015. Then the matter was posted for judgment and the judgment was given on 12/6/2015. Now the question arises is that when you pass the judgment, when the learned trial court is passing a judgment, or in that any judicial officer is applying his mind, then the records have to be looked into. Now, prima facie it suggests that on the day the judgment was already prepared, there was a defect, the 313 could not be found. So if there is no 313 on record, how can your lordship trial court may pass the judgment on that very day itself? First question. Second thing, my lord, is that if there was no 313 earlier, how can the paper book presently in the paper book, there are the 313 of earlier statements recorded by the learned predecessor at that point of time is there in this paper?
There's no.
Yes, my lord, it is there. The Honorable Justice Nandi, madam, has seen. Yes, it is there.
Where?
Yes, yes, my lord.
Twenty-five, 30. It's the first, 30.
Yes, my lord. It comes from page 58. Page 58. My lord is there. Your lordship will kindly see examination of accused Mintu Das under section 313 of CRPC, aged about 40 years. So and so, recorded on 25th day of April 2013.
What is the order you sent regarding that?
My lord, the order was on that very day.
No, not the judgment. Just prior to the judgment with regard to the.
Yeah, my lord, that
55
order will be there in the order sheet of the trial court. 12-6.
Is it, it's not in the paper book.
It is not in the paper.
Order dated?
12-6-2015.
So,
The day the impugned judgment was, the judgment was passed.
Okay.
already recorded that. And on the date of judgment, he didn't find the, then second time. the- This is hardly at home. 3 times, 313 was recorded. This is the same.
Yes, in fact, three times 313 was been recorded. Once, the first one was been set aside by this court while remanding it. Second was been recorded on 25th April. Third, during the time of the date the judgment was been passed, it was been recorded again.
No. Isn't it? So the same day, they recorded this. Just again. We'll get the judgment. It's a little.
My lord, if your lordship may permit. Well, if my lords permit me. I have already spent more than 12 years behind the bars. My lord, I have already spent more than 12 years behind the bar. On the last occasion, why I am referring your lordship this fact to demonstrate that there was, beside the the way the prosecution has, the investigating has been done, that's a different chapter altogether, which if your lordship I will come. But I want to demonstrate that when this division bench has remanded back the matter, the learned trial court acted in a very callous way and has recorded the judgment. Now, two things is there. One, your lordship may remand back the matter, but first thing, what purpose it will serve? Number one, because already we have been remanded back. The consequence was this.
No, but then that is your case, that there hasn't been an irregularity. If you say that the recording of the second 313 does not prejudice your case, then we will not remand it.
My lord,
But if you say it prejudices, then we'll remand.
my lord,
You
your lord,
have got to take a stand.
my lord, I'm going to take the stand, my lord. Why I'm putting it before your lordship, why I'm putting this story behind it, the facts is that to demonstrate that the very impugn judgment which has been recorded, it is primarily with a very careless manner, with all my
That is a different
thing. My lord, though it may be, thing is that now the question is that which 313 I am supposed to rely. That was the last time this court has put me this query. And after having a discussion with with the clients, I think I will go with the last 313 because that will be benefiting me. How? Because that 313 was not at all discussing the impugn judgment. Because earlier 313, 25th April 2013, I cannot rely because there is a judicial order that this is not found in the record. So automatically that second 313.
You see, a mistake does not give you any right. If there was a mistake on the part of the trial court in not finding that document, that is a human error. It might record anything, but if it was always there, then what is the wrong in considering that? How does it prejudice you if both the 313s are considered?
My lord, with that respect, your lordship, I will be saying that, my lord, 2-313 cannot be considered. How can the 2-313 statement can be?
No. Are you giving differing answers or differing or contrasting explanations with regard to the same evidence or something?
No, my lord.
Then
The question is that when the judgment which has been challenged, impugned here, it is based on the judgment has been recorded on the basis of the 313, which has been recorded on that very day itself.
let us see what is the difference between the two. 339. Let us.
And accordingly, my lord, on last occasion when these issues was been pointed out, my lord, may kindly see the order of this honorable court passed on 24th August.
25 for 25 for 30. Okay, yes.
Your lordship. It is not a question that, because I am afraid that it raises a question of law. How? Your lordship is fairly correct from that point of view, that if there are two 330 and if there is no discrepancies, why are you afraid of why the court cannot look into it? That's a fairly one side of the view. Second is that, which I am putting it, your lordship, that the London trial court, rightly or wrongly, whatever, if the judicial order has been passed, that on the day of the judgment, London trial court found that there was no 313, a 313 has to be recorded. And accordingly it was recorded. Now we don't know whether the 313 was recorded first on that very day of 12/6/2015 or the judgment was prepared before the 313. That we don't know. But if we go into the impugned judgment, read it, then we might find out something clue. But at this point, your lordship, on last order of this honorable court, this court has put a query that which 313 the appellant wants to rely upon, so that no prejudice can be claimed or this court may look into it. Now, that is one view of this division bench. Now your lordship is saying that if two 313 are there, because it's a part, both are the judicial record, part of the judicial record, your lordship. Which should one, why the court cannot look into it? So your lordship, I find, subject your lordship's view, whether it should be the second one or the first one. My lord, if your lordship finds that two views are there, or in two views, because they are division.
These are not views. These are not views. These are your statements. These are not views.
No, as your lordship has put a query to
The
me,
query is basically, yes. So you see the query, the view that we take, whether it should be, both should be considered or one should be considered. Can you give us some citation to help us?
my lord, as far as I believe your lordship, that the famous celebrated case of Raj Narayan versus Indira Gandhi, Indian Nehru. The question was there regarding the interpretation of section 85(2) of the RP Act while filing a complaint whether the allegation should be there or not. Then there the Supreme Court has held that provision of a law is not to be taken as a mere formality. It is a juristic perception is there, and it should be looked into in its true sense. Now here, your lordship, in this present case, after the matter has been remanded back to the trial court once records reveal that 313 was recorded. Now, once the 313 is recorded, then comes the prepared question of argument and judgment. Now the argument was being concluded.
No, you see, we are very sure of the fact that it's an irregularity.
My lord.
That much, so there's no doubt about it. The only issue is, now, it has to be said that it appears that.
Whether those irregularities are a fatal one.
No.
Goes in the court of the prosecution
actually,
case, yes.
You are writing a judgment
Yes.
on the day that you take down the 313 statement. Really goes to show that you have not, the argument should be after 313
Yes,
statement is
yes.
out here, the argument was prior. So,
I'm not aware of it because.
no, in the order itself, it is
My lord.
very clear. At page 67, he's given a list. Page 67 says date of argument 2005. Date of judgment 12/6. And on 12/6, he recorded 313. So that is very clear
Oh,
that this judgment is very regular and cannot.
Lordship, one more factor your lordship may look into, whether the judgment was delivered in an open court. It was like,
It says judgment on 26. What else? Whether it's open court or
no, it was
in the
dictated. it
chamber
was-
or whatever.
No, it was dictated.
Look, madam, she says here, given under my hand and seal on the court on this 12th June 2015, 12/6. So whether it was announced in open court or in the secrecy of the chamber, doesn't matter, it was done on 12/6. But argument was done 1 month earlier in May.
Mm.
Judgment announced on 12/6. Argument heard 1 month earlier. 313 done on 12/6. So that
The
is
face
wrong.
of it. Yes.
Huh?
Yes, at the face of it. Yes.
Naturally. So this cannot be, this I mean has to go. So tentatively, our view is that it should be sent back. From the stage of considering the 313 statement. Now, which 313 statement should the court look into? Whether it should be the first one or the second one or both? That is the bit.
My lord,
So
we ca-
he's saying that it should be the second one. Now, why it should be the second one? That's what he's trying to convince us.
no, your lordship,
One more factor.
your lordship may kindly come to the order of this court of 24th August.
24th August.
24th August.
Yes,
My lord is there.
24th August of,
23. The order passed in this appeal.
okay, in this.
So, extra copy, ma'am.
Yes,
The learned counsel for the appealants has brought on the notice of this court, that upon remand of the matter by this court, the learned session judge found that one of the accused was juvenile and his trial was segregated. And thereafter, the remaining two accused were examined under section 313 CRPC. It has been pointed out that as per order dated 12/6/2015, the learned session judge did not find the 313 CRPC statement on record. And therefore, on the date of pronouncement of the judgment of conviction, the accused was again examined under section 313 CRPC. Appraised, and the judgment impugned in this appeal was passed on the basis of subsequently recorded examination of the accused under section 313 CRPC. The learned counsel for the appealants has shown from the LCR that previous examination of the accused under section 313 CRPC dated 25th April 13 is on record at page 62A to 62D of file A of the LCR, and that the subsequent examination of the accused under section 313 CRPC dated 12/6/15 is available at page 74 to 81 of file A of the LCR. Having heard the learned APP, the court is of the considered opinion that it would be appropriate to give an opportunity to the appellants to take a decision as to whether they would like this court to hear the matters on the basis of examination of accused recorded under section 313 CRPC on 25th April 13, or the subsequent recording made on 12/6/2015, so that the appellants do not suffer any prejudice when the matter is taken up for hearing. Accordingly, the matter stands deferred today on the prayer made by the learned counsel for the appellants list on 25th August 2020. So, your lordship.
yes.
So, my lord, the reason for referring of this order is that this court gave the appellant an opportunity to choose between 2/313. Which one? The earlier,
No. Gave you an opportunity to give your views. Not to choose, basically. To give your views as to why one 313 should be considered over the other. It has to see whatever judgments we make orders, it has to have some rationale, some basis. We cannot do as we like. So it's not that if you can convince us that the law requires that the second one should be considered. Well and good, no problem.
my lord.
It's only that. So, or whether it should be two, we want to pass the right order. That's.
I
that's the
understand,
thing.
your lordship, I understand. Your lordship, the thing is that why I am trying to refer to this, why I am trying to rely on the second.
Yeah.
My lord. Is that the judgment was passed on the basis of the second 330. Second 330. And
Yes,
there is no whisper of the first 330,
correct. correct.
my lord. The record, because the judgment has been prepared on that basis. only. So now seeing the judgment has been impugned here. The only one thing which I wanted to draw the attention of this court was that the judgment in a very, which has been passed, was in a very careless manner, in a very in a very cavalier manner, the impugned judgment has been recorded. That is the only first upon. Now your lordship will see, my lord has to see that earlier I had been remanded, the matter has been remanded. The consequences was this. Now again remanding back the matter, where I have already spent 12 years behind the bars. I have got bail only during the COVID period. Now again remanding back the matter. Again, if a finding is recorded one way or the other way, we don't want to go through that trauma again. We don't want to go through that trauma again. So we want to hear this matter. If whatever the consequences, whatever the judgment follows from this honorable court, that's a different thing. But we don't want to go back again. Now, if your lordship put that which 313 has to be referred, that your lordship, I choose to go with the second one. But if your lordship wants the law on that point, lordship, I have to adjourn the matter because I will have to look for a judgment.
I think that is the issue.
Lordship.
The issue is whether both the Q1 will have to be considered. Say, forget about the trial court, even for this court,
Yes.
to decide the issue. Whether both the Q1 will have to be considered or only one has to be considered, and if so, which one?
And one more, lordship, one more aspect. Lordship, if the incriminating materials are not put to the accused person, it will vitiate the trial, your lordship.
No, so that has been put.
Yes,
That is
but
not the issue.
subsequently, as after the 313, like second 313. So I think he needs to rely on, I leave it to the defense side.
No, we are not on that. Madam, we are not on
No,
that.
no, first 313, lordship, it was not like, if I've understood it correctly, my lord, in first 313, incriminating materials are not put, matter was sent back, yes,
Matter was sent back.
yeah,
And then 313 was taken in April.
yes,
Then in May, the court heard the arguments again.
on the same day on,
No,
Yeah.
on May.
Yes.
May. Then on 12th June,
yes,
while passing, on 12th June, passed the judgment, final judgment, convicting them. Now on 12th June itself, the court said that 313 had been taken in April, but it is not on the record. So on 12/6 itself, again took 313.
yes,
Now, he says, look, the judgment has been made on the basis of the 313 statement, because evidence though is already there from before. That 313 statement on the day the judgment was. That means after the arguments were heard. So that cannot be allowed. So that way, we also are of the view that the judgment is very irregular. The making of
lordship,
judgment.
yes,
So
yes,
now, if we remand this case back to the learned trial court to consider the case from the stage of 313 statement,
yes,
now whether the trial court should consider both the statements made on made under 313 in April and in June,
yes,
or whether the court should consider the 313 statement in April or the one made in June.
yes,
That is the issue.
yes, lordship, then if he's taking time.
No, we want to, before taking that, we want to know your view though.
To my views, my lord, today, lordship, paper book which has been furnished to me by the office, and I don't know what he has furnished, it's not in full form.
I don't
Two
find it-
313s are not there, only one
That
313.
that is the problem with your office.
Yes, my lord.
Ah.
Yes, my
Three
lord, so
313,
lordship,
yes.
may I pray, if it takes time, in the meantime, a supplementary paper book be prepared by him and be furnished to me, my lord. Lordship, everything should be there on record because
Madam,
whatever is submitting,
Madam,
page 67, my record is different,
Madam, you see one thing, the court record and his record are the same.
but my record is
Now,
different.
now, why do you think that the registry will give you a separate
No,
record?
no, Lordship, it's a personal appeal prepared by him. Whatever furnishes, it will be provided by us to the, by the office of.
I
our
respectfully
office.
disagree with my senior colleague at the bar. Be it a private appeal or a jail appeal, the paper books are prepared by the registry. Registry itself.
Whatever maybe it's not, how come
Anyway,
it's
my
not
lord.
telling?
Your lordship is, let me come on different aspect on 313 now. Your lordship will appreciate there are a catena of judgment of on 313. Even on a celebrated case of 313 of Rina Hazarika, which has come from this principle, this High Court, went to the Supreme Court. The apex court has laid down that 313 is not a principle of just audio alternate partum. It is a canon of flow of Article 21.
No,
My lord.
there's
My
there's
lord.
no argument with that. Huh.
No, now question is that your lordship is fairly correct, and which I also agree. It didn't come in my mind, but I do agree now. That if your lordship remand back the matter, the trial court will proceed from the argument state 313. Which 313 is to consider? That's fairly correct. But that is why, your lordship, a peculiar legal problem has arisen. Which 313? So, your lordship, since there is a order of this court of 24th August, the lordship can formulate a query, issue, even both the prosecution and defense, we can give. And if it requires that it is to be settled, let it be referred to the full bench
Yes,
on this
yes,
issue, my lord, on
yes.
this issue.
So
No,
Lordship,
why full bench? First of all, if there are contradictory views or conflicting views of this bench, of a division bench, then we'll refer it.
My
If there is, why should we straight away say, well, first let us try to find out,
yes,
why should we send it straight away like that? Why should it go to the full bench? There's no justification
yes,
for.
my lord,
My
my
lord,
lord.
record this view that the 2313 aspect, even if we refer it, my lord, remand back the matter. Which 313 the Lane trial court will get? Because your lordship cannot set aside one 313.
Correct. We cannot set aside two or three.
None of the 313.
Yeah.
And even if I choose, for example, even if I choose that I will go with the 313 of the last
Now,
313.
whether your choosing is also sustainable in law.
Exactly, my lord, because
Yes,
the
my
state, anyone goes against the appeal, against this conviction, whatever.
Because these are only to give you a chance to explain. So how can you say that, no, that explanation of mine
Wishes
is
of
wrong.
mine,
This
yes.
explanation of mine has to be accepted. You'd have to, I think prima facie, it is your explanation. You have given under 313. Why shouldn't both be considered? Why, what is,
The problem is somewhere else, my lord.
no, the,
Problem is that on the basis of 25th, first, second 313, which has been recorded after matter was been remanded back. On the basis of that 313, the learned trial court asked me a query. Would you like to issue defense evidence? I told yes, I will let.
okay.
Now, in the impugned judgment, it is recorded. There is no 313. Earlier 313 was not there. So we are recording it. And at the last, we would like to adduce defense evidence. That we told that we will be going with our earlier evidence. So now the question is that the learned trial court,
Okay, in the April 313, you said that you wanted to adduce evidence.
no. Yes, the first, second 313 after the
Second
matter was
313,
remanded back.
let us see
My
which page.
Page 39.
Page 39, yes, where did you say?
My lord. My lord. My lord will kindly find at page 58.
58 is the second. 58 is the third 313. No, 58 is the second 313. Yeah, correct. So where are we?
Your lordship will see, your lordship will find that Mintu Das.
Yes,
My
page
name is-
60. Will you adduce evidence? I
Yes,
shall not. I
My
shall
lord,
not.
I shall not.
Ah.
Now, your lordship will kindly come to the 313 of last 313 recorded,
Page.
page 44. Will you adduce evidence in your defense? I have already adduced evidence and I have No witness to examine in
No,
defense.
same thing. I have got no defense to examine.
No. Second 313, your lordship, which has been recorded. It was saying that will you adduce any evidence?
They said no.
No.
Page 44 now.
My lord.
I'm really finding it difficult, your lordship, to do the case.
Just a minute,
Please just
madam.
do not tell me, my lord.
That is your problem, madam. Just wait.
Your lordship will see in
Yes.
this
Page 44, you come
Page-
page 44.
page 44.
Ah,
I have already adduced evidence and I have no witness to examine in defense.
yes,
So both these 313,
yes.
this last one, the second one,
Ah,
last and second one,
Ah.
I had no evidence because I have already given evidence.
yes, so that will be
That means,
considered.
that means the first 313, which was been remanded back.
No, sorry. That is not the case. You have already, you see, the defense witnesses were there. So, and when the case was remanded back by this court, it was from the stage of 313. So
See.
all the things prior to 313, they still stand. Prior to 313, all the evidence that had been recorded by the trial court still stand.
Yes,
Then what is the
yes,
problem?
no. What I am saying is that when the first conviction was recorded, at that point of time, the matter came before this court. First conviction, your lordship, I have given a chart.
No, you tell me,
My lord.
we've heard it.
We Session Court convicted us on 27/2/2007. My lord,
Yes, then,
yes.
So?
Though that conviction was definitely, there was a 313, my lord.
yes, that was not allowed.
That was not allowed,
Yes, so.
not allowed not in wholesale, my lord. It was only specific to
So
putting
some more
question of
incriminating-
PW 1, 2, 4 and 6. So the second 313 comes,
You see, the first 313 is of no relevance because the court had said that since incriminating materials that had been found in the evidence had not been put to you, so those should be put to you in 313. Accordingly, the second 313 was taken.
second
Now,
313
second 313 does not say that the evidence adduced by the defense witnesses earlier should not be considered. Where
No,
does it?
It has
Then-
been considered, my lord.
Then
It
what
has
is
been,
wrong?
no. What I'm saying is that second 313, your lordship, will see two differences there. Second 313 was restricted to the witnesses,
Correct.
which is planet trial, which this honorable court remanded back. That is 1, 2, 4 and 6. Now, second 313, your lordship, if you say your lordship says that the earlier 313 goes away because the moment has been remanded back. The last 313, the third one, the trial court has recorded the evidence of all the PW1, all the evidences in general.
So,
The second 313 was only with respect to 1, 2, 4 and 6 as per the direction of this court.
no, it does not confine itself, does it?
Yes, my lord, it does. Your lordship will see.
No, it says that none of the incriminating circumstances contained so have been laid.
No, my lord, your lordship is referring to the judgment.
No, these are just examples. How does it matter? How does it matter? Anyway, right, we'll give you one chance to
Lordship, I'll
give
collect the
citation.
paper book from him. I'll get it Xerox, my lord.
So, madam, this.
Our problem, let us solve it. by ourselves.
Yes. Now the issue is very small.
Yes.
Very small.
Yes,
Whether the learned trial court or even this court has to consider the 2313 statement or one,
1, 2, 1.
and if one, which one? That's all.
Yes,
Nothing.
day after tomorrow.
And not only that, why not the first one also?
Yes.
There's nothing,
No.
because there's nothing in the first one. There's nothing prejudicial to it.
Your lordship, and I will make a humble submission is that. Your lordship may pass this order. In here, I believe we have filed an certified to be true for certain document. We have applied for certified copy. Couple of days, right after the order passed by this bench of 24th August. But the file was not been sent to the registry, so I'm unable to secure certain paper. My lord may kindly,
Those we'll do later on. We'll finish up this issue first.
Let the matter be kept as part.
Oh, what is it? We're not running away from anything. Heard Mr. S. Borgohain, learned counsel for the appellant. Also heard Miss L, Miss B. Buyan, learned additional PP appearing for the same. So stop, right? The appeal has been filed against the impugned judgment passed by impugned judgment dated
12/6/15.
12/6/2015, passed by the
Session Judge Golagar, my lord.
passed by the Session Judge Golagar in Sessions Case number 139/2013, by which the two appellants have been convicted under Section 302/34 IPC and have been sentenced to undergo
Life imprisonment, my lord.
imprisonment for life with a fine of rupees 5,000 each, in default SI for 2 months. They were also convicted and sentenced to undergo SI for a period of 1 month under section 323/34 IPC. And SI for 15 days under section 341/34 IPC. The learned counsel for the appellant submits. No, don't say, let's say that the brief facts of the case is that the the two appellants in this case and one Pranab Jyoti Das
My lord.
had been convicted under section. Where is that trial court judgment? Is it here?
Your lordship, the first judgment. It is not there in this paper book, my lord.
No, in the record.
It should be in the record, my lord. The lordship will that the date of the judgment is 27 February 2007.
Yes, what have I said? Have been convicted under section 302/34. T41 and T23/34 Act. By judgment dated 27/2/2007. Passed by the Session Judge Golagar. Session case number 139/2007. Next para. The appellants and Pranab Jyoti Das thereafter filed criminal appeal 76/2007 before this court. Criminal appeal 76/2007 was disposed of by order dated 5/12/2012. And directing by remanding the case back to the learned trial court from the stage of examining was remanded back to the learned trial court to determine the plea of juvenility taken by Pranab Jyoti Das. Thereafter, the learned trial court was to deal with, was to proceed with the case from the stage of examining the appellant's hearing under section 313 CRPC and record its final verdict. Full stop. Next paragraph. Consequent to the order dated 5/12/2012 passed in Criminal Appeal 76/2007, the learned trial court examined the plea of juvenility taken by Pranab Jyoti Das and held that Pranab Jyoti Das was a juvenile. Full stop. Thereafter, the learned trial court proceeded with the case against the appellant's hearing by taking their by examining them under section 313 CRPC on 25/4/2013.
Yes.
Full stop. The final arguments of the parties was thereafter heard by the learned trial court on 20/05/2015. Full stop. And the case was disposed of by the impugned judgment dated 12/6/2015, wherein the appellants were convicted under section 302/34, 341 and section 343/34 IPC.
323, madam.
323, 321, then 323 slash 341, then 323/34 IPC.
Madam, that.
However, next para, no, continue. However, the learned trial court had also passed a separate order on the date of disposal of the case, that is on
12/6/15.
12/6/2015, stating that the trial court could not find the record of the examination of the appellant under section 313 CRPC made on 25/4/2013. Accordingly, a fresh examination of the appellant was undertaken by the learned trial court on 12/6/2015, that is the date the impugned judgment was passed by the learned trial. Next paragraph. On perusing the records, on perusing the LCR, we find that we have found the record of the previous examination of the appellants under section 313 taken on 25/4/2013. However, as the learned trial court was not aware and had not taken into consideration the examination of the appellants under section 313 CRPC on 25/4/2013, it is quite apparent that the impugned judgment. No, that there's quite apparent that there is irregularity in the manner in which the impugned judgment has been passed. Puspa. Next paragraph. Assuming that the case is remanded back to the learned trial court from the stage of examining the appellants under section 313 CRPC, comma, the question that arises is as to whether the examination of the appellants under section 313 on as to whether the examination of the appellants under section 313 on 25/4/2013 would have to be taken into consideration, or the examination undertaken on 12/6/2015.
My lord, it was
The other alternative is as to whether both the statements taken on different dates would have to be considered by the learned trial. The next para, the learned counsels for the party shall
My lord, your lordship may refer to the last order.
Huh?
Last order of this court.
Ah.
The lordship,
the learned counsels for the party uh, shall make submissions on this on this ground, as well as the, by keeping in view the earlier order dated 24/8/2023 passed by this court earlier. Also. List the matter on when.
can it be, my lord?
Yeah, so tomorrow.
The day after tomorrow. Can it be on, my lord, Monday, next Monday?
Coming Monday. Oh, it is a holiday, second.
Monday is holiday.
No, Monday,
Third then.
third, my lord.
List the matter on time.
My lord, 313 of your lordship has recorded 25/4/2013. It should be 25/4/2014.
No, 2013. 13.
My lord, here order is reflected again. The trial court's order, 25/4/2014.
We have seen the record in the front of us.
If your lordship sees that order of 12/6/2015.
No, let us see page 58 straight away. No, not 48, 39, I think. No, 58.
It is written 2013,
Correct.
2013. But the judicial order, your lordship, of 12/6/2015. The records reveals that both the accused are examined under section 313 CRPC on 25 April 2014.
That is the typographic. That is a mistake. That is there in the there in the order sheet. The order sheet clarifies that. There's the order pass.
Unfortunately, too many clerical mistakes, my lord.
It happens. To err is human. You've got to be slightly, understanding. That is why, that is why these cases are here. When you err, you make mistakes.
Oblige, your lord.
Only on the short point, basically. Where is the council? PJ Sakia.
Oh, Lordship, it's, the causes is showing a J Sakia. J or PJ, my lord.
अच्छा J Sakia, yes, J Sakia. You see, the problem is on May 22, none appears for the appellant. Then on 17/1/23, none appears for the appellant. 30/01, none appears for the appellant. Then next, amicus curiae is absent. Then next, Ms. J. Jahan, S. Jahan, prays for a short accommodation. But then it appears that amicus curiae is not coming. So we'll appoint
It will
somebody.
be replaced.
But let us see where the paper book is. Has it been given to? J. Saiki has also received a copy of the paper book. Okay, right. No one appears for the appellant. The orders dated 13/5/22, 17/1/23, 30/1/23, and 10/5/23. So that no one has appeared for the appellant. Accordingly, we are of the view that the amicus curiae appointed for this case should be replaced by a new amicus curiae. The new, who,
The list is different.
accordingly, so and so is
Vijita.
appointed, huh? I don't know, so accordingly,
Vijita.
so and so is appointed. Accordingly, Miss, this is
Vijita Sharma.
Vijita Sharma is appointed as amicus curiae. And this is to provide copy of paper book to Miss Vijita Sharma. This is the matter.
And her name be reflected in the causes.
Most of her name will also be reflected in the causes. This is the matter after a week.
After.
Acha. Yeah, just. This is not.
I thought I am appearing for the respondent. Read petitioner.
Yes.
My lord, Mr. Nair are good for the High Court. I think that his part is over.
He wanted to give up, refresher. I think that will be required, long time back. Long time back. Anyway, what you can tell us, why you made the challenge to.
Yes, yes. Or what it can be done, my lord, I can conclude my part. By your reply, they can say whatever
Yes.
they like to say.
That also, that will also.
My lord, basically, we are challenging
Yes, start as a writ petitioner. So that
as a writ
will
petitioner.
come.
Yes. My lord, basically, we are challenging the appointment of respondent number 5, my lord.
This point number 5 in the writ petition.
Yes, as a private secretary to the Honorable Chief Justice.
On what ground?
Number 1, my lord, he is not eligible in terms of the relevant rules.
Which rules?
The service rule, my lord.
Which rule?
Yes. Guwahati High Court Service Rule 1967.
Which provision basically? Any particular provision?
Yes, yes. Basically, my lord, rule 3 capital A.
Rule the capital. Okay. Which says?
It says secretary to the Honorable Chief Justice shall be appointed from amongst the gazetted officers of the High Court Service belonging to class 2AA, class 2B, or class 2C, having a law degree in law considered suitable by the Chief Justice. My lord, he is neither in either of the classes, nor he is a graduate in law. Though an argument was advanced that, my lord, he belongs to 2C, I'll show, my lord, why he is not.
Not a graduate in law.
Not a graduate in law.
So how did this, not a graduate in law, how was this overcome?
He doesn't have, my lord.
No, so how was it overcome? By who? By his
The records will reveal, my lord. The records will reveal.
was it some relaxation given to him or something?
Yes, there is a provision of relaxation, but my lord, essential requirements cannot be relaxed. What can
So
be
it was,
relaxed?
so, no, it was promotion was relaxed.
No, my lord.
This condition was relaxed.
Actually, my lord, it is a promotional post,
Ah.
but he was not promoted. He was selected. It is a promotional post. Can I place the facts, my lord?
Yes.
Yes. If your lordship will take writ appeal number 5 of 23, my lord will first come to page 140. Hat number 2 there. Writ appeal 5 of 23.
Page.
Page 140. The Guwahati High Court, so and so, has been pleased to encadre the post of protocol officer and assistant protocol officer in the principal seat with retrospective effect from 25 to 99, and accordingly pleased to amend Schedule 1 of the Guwahati High Court rules, so and so, so and so. So, my lord, the post of protocol officer came to be encadred in the rules with effect from 8/6/2011. Then, my lord, will kindly come to page number 144. In exercise of the power conferred under Article 229 of the Constitution of India, read with Rule 6 of the Guwahati High Court Service, Appointment and Condition of Service Rule 67. Honorable the Chief Justice has been pleased to appoint Nirud Sharma, Senior Judicial Assistant temporarily and until further order as Protocol Officer in the principal seat of the Guwahati High Court at Guwahati in the pay band of so and so, etc., with effect from the date of his joining Vice Diganto Goswami, Protocol Officer released from the High Court Service. Now, this is very important, my lord. Nirod Sharma will maintain his seniority in the original cadre, that is Senior Judicial Assistant, and his further promotion will be considered on that basis. My lord, there is a background, my lord, how this order came to be passed. I'll place little later. Now let me place the facts. While, my lord, he was holding the temporary post of protocol officer, my lord, He was, my lord,
Temporary post,
purportedly,
temporary post?
it's a temporary post, my lord,
Okay. Temporarily appointed.
temporarily appointed. And that the fact that he will maintain his seniority in his original cadre means it was just a stopgap arrangement, my lord. It was not a substantive appointment. Because for a substantive appointment, my lord, regular promotion has to take place. Because protocol officer has to be promoted from the cadre of my lord, senior judicial assistant, SJA. I'll place the rules.
Appointed from?
Senior judicial assistant.
So
That is his,
that is his post.
no, my lord, he was substantively, he was a senior judicial assistant.
Ah.
While he was holding that post, he was temporarily promoted as protocol officer by order of page 144.
Correct.
Yes,
So protocol officer has to be appointed from where?
from my lord, senior judicial assistant.
That is what he is
He has been appointed temporarily.
as senior judicial assistant. No. No,
He
no.
has
What,
been-
what is the feeder post for promotion for protocol officer?
Senior judicial assistant.
So he's senior. Please read the order notification.
Yes, I have read it.
It says.
Temporarily, he is
He-
appointed. He's not promoted, man. He's
Okay, temporarily,
appointed.
temporarily appointed.
Appointed. not
Anyway, but he's in the feeder post.
promoted.
Anyway, he's in the feeder post.
He's in the feeder post, but he's the junior most. There are
Okay,
people
okay.
who are all senior to him, madam. Oh, that way, yes, Lordship is correct. But he is the junior most. Then my lord will kindly come to page 145.
Yes.
In exercise of the power conferred under Article 229 of the Constitution of India, Honorable Chief Justice has been pleased to appoint Niroj Sharma, Protocol Officer, temporarily and until further order as Secretary to the Honorable Chief Justice on officiating basis in the principal seat of the Guwahati High Court in the pay band of so and so, etc., under the rules with effect from the date of his assuming charge. Now, this is important. Niroj Sharma shall maintain his seniority in his original cadre of senior judicial assistant, and this further promotion will be made on that basis. So substantive appointment was still senior judicial assistant. Now he was, my lord, given the officiating charge of Secretary to the Honorable Chief Justice. Now comes the final impugned order, my lord, at page 146.
Yes.
In exercise of the power conferred under Article 229 of the Constitution of India, read with Rule 63A of the Guwahati High Court Service Rules, so and so, Honorable the Chief Justice has been pleased to regularize the appointment of Sri Niroj Sharma as Secretary to the Honorable Chief Justice with effect from 4/7/2020, which was made by Registrar's notification dated 10/9/28. So, my lord, the two orders, the officiating, sir, this order is under challenge and which has been interfered with by the learned single gentleman. Yes. Now, my lord will kindly come to my lord, page number 69.
Yes.
Yes, kindly, Lordship will kindly come to page 79 for a moment.
Yes,
Kindly, this is the, my lord, the organizational tree looks like.
organizational chart.
Yes, page 79, my lord.
Yes,
Kindly see, my lord, judicial assistant, that is the entry level post. Or what we call LDA, my lord. Then the next promotional post is senior judicial assistant. Then, my lord, administrative officer judicial in one channel, assistant register, deputy register, joint register, register. Then the other channel is, my lord, from senior judicial assistant to court officer, court master, court officer, then secretary to the Honorable Chief Justice. And the other channel is, my lord, from senior judicial assistant to protocol officer, then to Honorable the Chief Justice, secretary to the Honorable the Chief Justice. Now, my lord will kindly come to,
now before that,
yes,
now page 79,
yes,
the promotional post of SJ is administrative officer judicial, is it?
also, my lord, court officer,
Court officer and protocol
protocol
officer.
officer.
And what about this court master?
Also court master, my lord.
Is it a promotional post?
My lord, as far as court masters are concerned, I think, my lord, the rule specifies a provision, but only problem is, my lord, the protocol officer, my lord, following encadrement, it has to be constituted to be a promotional post from SJ. I'll show that, my. Let me place the facts. I'll come one by one. Then, my lord will kindly come to the seniority position among the senior judicial assistants. Please come to page 69, my lord. Now, list showing dates on which petitioners were promoted as AOG, that is above, my lord, senior judicial assistant. For example, petitioner number 1, my lord, he became an AOJ on 1/12/2022. 21, sorry. Similarly, this is how, my lord, they all became AOJ. And the respondent number 5, Mr. Nirod Sharma, my lord, he was still in that feeder cadre of, my lord, SJA. Then, my lord will kindly come to page 73, gradation list of the senior judicial assistant.
Yes,
along
yeah,
with the-
page 69. I
Yes.
mean, the years are not,
Not very clear, my lord.
no, it's cut, it's not here at all.
Uh-huh.
201.
Anyway, my lord, I'll have a better copy of this, my lord. Lordship will kindly come to page 73. Lordship, for a moment, Lordship can ignore that.
Anyway, so out here, this person is
No,
not here.
Lordship will kindly come to page 73,
Ah.
the gradation list amongst the, my lord, senior judicial assistant. এখন আমরা কি দিছে? এটা দিতে নাই। Actually, my lord, the appeal is by them, my lord. They have given the copy. Anyway, my lord will kindly come to page 73,
Yes,
gradation list of senior judicial assistant.
yes.
Now, my lord will kindly come to page number 45. 75. 75. Serial number 45. He is the appellant, respondent number 5. And the writ petitioners are all above him.
And some of them are in the promote.
AOJ.
Uh,
Most of them are in the AOJ.
No, so those, okay.
Most of them are on AOJ. That's why their name do not figure in the list of senior judicial assistant. So, my lord, now Lordship will kindly take the let us have the look at the rule position. এখান থেকে ওঠা।
One more.
এখানে আছে দেখুন তলত এখন এখান
Yes,
My lord will kindly come to page 638.
yes,
Service of the Guwahati High Court shall consist of both gazetted and non-gazetted posts and shall be classified as follows. 2. The High Court Service, Class 2, 2A. High Court Service of Private Secretary Special, Class 2B. High Court Service Ministerial, Class 2C. Special Post 2D. Then my lord will kindly come to subsection 3 capital A, sorry, rule 3A of rule 7 at page 640. Secretary to the Honorable Chief Justice shall be appointed from among the gazetted officers of the High Court Service belonging to class 2AA, class 2B, or class 2C, having a degree in law considered suitable by the Chief Justice, provided that no gazetted officer of the High Court belonging to any of the classes mentioned in this sub-rule shall be eligible for appointment as Assistant Registrar Judicial unless he has got a law degree. So, my lord, neither Secretary to the Chief Justice nor Assistant Registrar Judicial, my lord, an incumbent can become until and unless he has a law degree. Then my lord will kindly come to page number 664. Schedule 1.
yes,
Towards the bottom, my lord, class 2AA. Librarian cum research officer, senior private secretary. Then class 2B, private secretary, grade 1 stenographer attached to the Honorable Chief Justice. Private secretaries, grade 1 stenographer attached to the Honorable Judges. Other grade 1 stenographers. 2C, administrative officer judicial, stamp reporter, court officer, protocol officer, assistant librarian, senior system officer. Then 22D, my lord, court master. So, my lord, what is very clear from the rules is, my lord, protocol officer is a post which is encadered in class 2C. And therefore, my lord, and if your lordship will kindly come to below, that ministerial establishment non-gazetted, class 3A, senior judicial assistant, including accountant, editor, etc., commissioner of affidavit, etc., etc., etc. Then, now, my lord, this respondent number 5,
yes,
until the order of regularization, which is under challenge, he was substantively holding the post of senior judicial assistant, which is in class 3, ministerial, non-gazetted. He was not holding any post of, my lord, any post under class 2, either A, B, C, or D. Now, my lord will kindly come to page.
according to you,
Yes, yes,
now the basic thing you're saying is that he was appointed
as a protocol
as a
officer.
protocol officer.
Yes, temporarily, that's why
He should have been promoted.
he should have.
Now, the other persons
Yes,
that you were showing at page 69,
yes,
whether those persons have been promoted,
yes, from senior assistant, SA to
can you show me
AOZ.
those promotion
AOZ,
orders?
yes, yes, promote.
Those promotion orders
Yes.
are with you.
Yes. My lord will kindly come to page 662. Six six two.
Yes,
A residuary power 63. Nothing in this rule shall be deemed to affect the power of the Chief Justice to make such order from time to time, as he may deem fit in regard to all matters incidental or ancillary to this rule, not specifically provided for herein, in regard to matters as have not been sufficiently provided for. Provided that if any such order relates to salaries, allowances, leave, or pension of the member of the Guwahati High Court service, the same shall be made with the approval of the governor of the state of Assam. Now, apparently, my lord, in the impute order 63, capital A has been invoked. Chief Justice shall have the power to relax age or qualification for appointment to the services of the High Court in appropriate cases according to his discretion. So, my lord.
so qualifications,
Yes, no, I'll come to it, my lord. Now, there are judgments on this. There are judgment of our High Court, my lord. I'll place up. Now. What is very evident is, my lord, the appointment of respondent number 5 or the appellant
yes,
as secretary to the private secretary to the Honorable Chief Justice is apparently violative of, my lord, sub rule 3 capital A of rule 7. Because he is neither in the feather cadre, be it promotion, be it selection, he has to be in the feather cadre. That is, my lord, protocol officer or my lord AOJ, or whatever it is. Secondly, he is not a graduate in law. My lord,
so 7(3)(a),
yeah,
that is again at page 640.
yes,
Okay.
now for a moment, Lordship will kindly take the Constitution of India for a moment, my lord.
Okay. Yes,
My lord will kindly have Article 229. Because Article 229 read with 63A, that appointment has been made.
yes,
Appointment of officers and servants of a high court shall be made by the Chief Justice of the court or such other judge or officers of the court as he may direct, provided that the governor of the state may by rule require that in such cases as may be specified in the rule, no person not already attached to the court shall be appointed to any office connected with the court, save after consultation with the State Public Service Commission. Now, my lord, in this case, sub-article 2 is very important. Subject to the provisions of any law made by the legislature of the state, condition of service of officers and servants of the High Court shall be such as may be prescribed by the rules made by the Chief Justice of the court or by some other judge of the or officers of the court authorized by the Chief Justice to make rules for the purpose, provided that the rules made under this clause shall, so far as they relate to salaries, allowance, leave, we're not concerned with a proviso, but we are seriously concerned with 229(2). It starts with the word subject to the provisions of any law made by the legislature of a state. the condition of service of officers and servants of the High Court shall be such as may be prescribed by Chief Justice. My lord, before the Honorable Chief Justice can exercise his discretionary power under my lord 63A, he is bound by sub-article 2 of Article 229, which says, subject to any law made by the legislature or any rules made. And the rules of 1967 is there. When rules of 1967 is there, whether Chief Justice can overlook that when it comes to exercising his discretion. There are Supreme Court judgment which says it cannot. So, my lord, that word subject to the provisions of any law made by the legislature assumes importance in this case, my lord. In my humble submission, my lord, Chief Justice must have due regard to the recruitment rules which governs the conditions of service. Chief Justice cannot exercise any discretion, my lord. It rehearses the rules framed for determining or governing the condition of service. Now, what is the rule? That you must be in the feather cadre and LLB. You are none of them. My lord, it is a well settled proposition of law. Conditions of recruitment cannot be relaxed, my lord. What can be relaxed is a condition of service. It's a condition of recruitment. Otherwise, my lord, there will be chaos. Now, my lord, before I articulate my arguments, let me deal with one aspect of the matter, my lord. Why that clause that he will continue to maintain his seniority in senior judicial assistant came to be incorporated when he was temporarily appointed as a protocol officer? Why we have not challenged that order? We have not challenged that order because he continues to be a senior judicial assistant. And I'll give that background, my lord, because an opportunity was given to us to peruse the records, my lord. And upon perusal of the records, what transpired is something which I'll indicate to your lordships. From perusal of records, what we found, my lord, extra copy nahi hai. Lord, we have made a note from the records. Lordship's kind permission. Can I just one page, my lord, photocopy, my lord? Can I share with the lordship? Is that photocopy nahi?
No, there is no photocopy here. We don't have.
Oh, okay. Anyway, my lord, I'll hand over a copy. My lord, what we find from the records, my lord, that I'll place one by one. On 25/2/99, the post of protocol officer came to be encadred in the rules. 25/2/99, that page 140 I have already indicated. Page 140. Page 140, my lord. 8th of June 2011. Guwahati High Court so and so has been pleased to encadre post of protocol officer. Yes. Then, my lord, the post of protocol officer is classified as class 2C. Which is, my lord, equivalent to, my lord, that post of AOJ, Administrative Officer, Judicial. My lord, there was a departmental promotion committee held on 11/6/2011, whereby it was resolved that the post of protocol officer will be filled up by promotion. But will kindly mark that date. I'll give this, my lord, once I complete, or I'll give a fresh printout, my lord. 11/6/2011, it was resolved that post of protocol officer shall be filled up by promotion from the feeder post of assistant protocol officer and eligible senior administrative assistant, judicial assistant within the zone of consideration with the application prevalent norms of the High Court. Then what we find, my lord, accordingly, my lord, 5 senior judicial assistant in order of seniority and 1 Randip Das, assistant protocol officer, was directed to appear for an oral interview held on 24/9/2011. Following that, my lord, Randip Das, APO, was promoted to the post of protocol officer by notification dated 29/9/2011. Sequence of events. Then Randip Das, protocol officer, later on submitted representation for redesignating him as a superintendent, now AOJ, which was disposed of by resolution of the judges committee meeting dated 6/2/14. Considering the fact that post of protocol officer has been encathered in the High Court rules, which is equivalent to the post of administrative officer judicial in the same status, rank and pay scale, committee resolved that Randip Das should be deemed to be in the cadre of AOJ with effect from the date of his promotion as protocol officer. Then, my lord, by the notification dated 12/2/14, Randip Das was posted as AOJ with retrospective effect. In the subsequent period,
Was posted as AOJ.
AOJ administrative
From the day he was
officer.
promoted as protocol.
Yes. In the subsequent period, the Honorable Judges Committee directed to call option for filling up the post of protocol officer and assistant protocol officer as per resolution dated 24/3/2014. Now, my lord, there was a slight departure. Then, my lord, what had happened? Guwahati High Court Employees Association submitted a representation dated 25/4/14 for filling up the post of protocol officer, APO, as per the prevalent promotion rules or for formulation of rules for filling up the post of protocol officer and assistant protocol officer, as inviting options from the intending senior judicial assistant, leave the scope for supersession of able senior incumbent in the cadre in future when the occasion for promoting incumbents holding the post of PO and APO will arise. Now, my lord, the senior judicial assistant, they had seen, my lord, what transpired was that, my lord, if this system of inviting option is permitted, then it so happens, my lord, some senior eligible, candidate may also be left out. Now, my lord, this representation was dealt with by a judges committee. As directed, the registry obtained information from other high courts regarding filling up the post of protocol officer, and the same was laid before the judges committee. Accordingly, the judges committee by resolution dated 9/3/15 directed that selected candidate for the post of PO will maintain their respective seniority in the original cadre, and their future promotion will be considered on that basis. From March 2015 onwards, the said criteria is being followed in case of filling up.
Just read that question.
My lord.
Just read it again.
Yes. Accordingly, the judges committee, by resolution dated 9/3/15, directed that the selected candidate for the post of PO and APO will maintain their respective seniority in their original cadres, and their further promotion will be considered on that basis.
This is by way of option exercise.
Yes, that was 9/3/15. Now, my lord, I'll give the pages. Lordship may kindly take note.
Why don't you give us a note?
I'll give.
Better.
I'll give. No, I'm just indicating.
Yeah, you can give them.
Of course, I'll give.
That
We'll
will
give.
help.
During the recess, we'll make it and give it, my lord. Now, what had happened, my lord? Now, based on the representation, this 9/3/15 meeting was held. And that is at, my lord, page 54 of the records. Now, what the Honorable Guwahati High Court did, my lord, they have adopted the Kerala model. In Kerala, what was being done, my lord? In Kerala, they, my lord, they feel the practice in Kerala High Court was, my lord, during the tenure of a particular Chief Justice, if a particular officer is appointed, he will, my lord, continue in that office till such Chief Justice holds office. The moment, my lord, he leaves, the successor may continue, may not continue. If he continues, well and good. If he is not continued, he will go back. In other words, my lord, the posts were coterminous. That is why, my lord, this particular clause was inserted, that he will maintain his seniority in the original cadre of senior judicial assistant. Therefore, my lord, we have not challenged that order because, my lord, it does not confer him any substantive right. He was given an officiating promotion. He was not given a permanent substantive promotion. That is why, my lord, we have not challenged. The whole idea is, my lord,
Which order not challenged?
that order promoting him temporarily as protocol officer. The idea is, my lord,
Yes,
the person who is selected as PO, he will discharge or he will hold office during the pleasure of the Chief Justice. The day Chief Justice retires, he is supposed to go back. That is why it is said he will maintain his seniority as SJ and his further promotion will be on that basis. Therefore, my lord, there was, my lord, otherwise, my lord, why High Court will incorporate on the administrative side, incorporate that condition? Some meaning has to be given, and meaning we have culled out from the records.
how many posts of protocol officer are there?
There are one protocol officer, one assistant protocol officer. One assistant, one. Oh, sorry, my lord, two. Two protocol officer and one assistant.
So so if two protocol officer posts are to be filled up, then zone of consideration will come into play.
5. There is High Court has taken decision on that also, my lord. In fact, my lord, that is the decision. A notification dated 11/12/13 issued by the Chief Justice. That is, my lord, page 28 of the records.
I think you have to give us a note.
Yes, we'll give, my lord, we'll give.
We cannot,
Notification that
we cannot keep all
No,
those dates. and all.
certainly, my lord. I'm sorry that I thought it is there in the file. I'm very sorry for that, my lord. Notification dated 11/12/13 issued by Chief Justice, fixing the zone of consideration as 1:5. That is for one post, 5 incumbent. There's further, my lord. And that is page 19C of the record. A meeting was held on 21/5/14, wherein representation filed by that I have already indicated, my lord. That representation was considered. That is how 9/3/15 decision was taken at page 54. So, my lord, this is the background under which the protocol of respondent number 5 was given an officiating appointment as a protocol officer, whereby it was made say that he will maintain his seniority as senior judicial assistant, and he will enjoy that office at the pleasure of the incumbent Chief Justice. The day Chief Justice goes, he will have to come back. So therefore, my lord, to say that it was a case of selection, not a promotion, which is envisaged under the rules. Because since he is in the, my lord, promoted cadre, and he was selected, my lord, he was selected by a committee, page 122 of the note sheet, my lord. He was selected by a committee of the honorable judges dated 23/11/16. It was Honorable Chief, Honorable Rishikesh Roy, Honorable Ujjal Bhuiya, and Honorable Justice Ashian. And item number 2. At page
Selected as
120,
what? Selected as what?
protocol officer. As protocol officer. On the
Out of the options given.
on temporary basis. So that is why, my lord, I have already, I will not repeat that. That is why we have not challenged. Now, my lord, let us come to the substantive challenge. Now, here our argument is very simple, my lord. Since you have uncathered the post of protocol officer, therefore it's a promotional post and you are to promote from amongst the eligible senior judicial assistants within the zone of consideration. That admittedly has not been done, number one.
Where is the rule? This
Yes.
is the-
If your lordship should kindly come to my lord, page 665.
Yes,
Class 2C, my lord, Roman
Yes.
4, protocol officer. One is administrative officer judicial.
yes,
And if your lordship kindly comes down below, ministerial establishment non-gazetted, class 3A, senior judicial assistant. Now, my lord,
no, but where does it show that this is the,
No,
this is
no,
there the.
there is no express provision in the rule, my lord. But my lord, having regard to the other provisions in the rule, that's the only option perhaps, my lord, to infer. Now, if your lordship will kindly come to my lord, rule, sub-rule. Sub-rule 5 of rule 7 at page 644, my lord. This is regarding court master, my lord. Court master is a post which is in 2DD. Same pay scale as that of my lord protocol officer, administrative officer judicial. In respect of that, provision is specific, I have expressly provided, my lord. Post of court master may be filled up by selection on the basis of merit cum seniority from among senior judicial assistant, so and so, working at the principal seat of the Guwahati High Court, having 8 years of experience as so and so, or both combined. Preference may be given to so and so, having degree in law from any recognized university. Then, my lord,
Where are you reading? Where are you reading?
page 644, my lord. Towards the bottom,
Yes,
this is sub-rule 5 of rule 7. This is regarding a method of recruitment to the post of court master, which is equivalent to, my lord, the court officer and my lord protocol officer and all. The post of court master may be filled up by selection on the basis of merit cum seniority from amongst the senior judicial assistant working at the principal seat of the High Court, having 8 years of experience as so and so, or both. Then my lord will kindly come to nature of
No, ju- ju-
appointment.
just one thing,
Yes,
this 7.5 talks of
court
It's-
master.
court master from among senior, from SJ and J.
J, judicial assistant.
Now, is SJ and junior of the same grade?
No,
Then how can they both be from this, how can they both be the feeder post?
no, junior assistant is, my lord, like, একটা হিন্দিতে আছে, junior assistant 99 or, oh, একটাতে আছে। No, according to the rules, my lord, SJ and J are in the same thing, my lord. Ministerial establishment, non-gazette, class 3A,
Where do you get that?
page 666. 666, my lord, on top, Roman 6, judicial assistant 99. Ministerial establishment, non-gazetted, class 3A,
Oh.
Roman 4, judicial assistant.
Pay scale is different.
Pay scale is different. Pay scale is different.
So a judicial assistant and judicial assistant.
Yes,
There's something not right.
But my lord, from judicial assistant, one has to get promoted to, my lord, senior judicial assistant. It's something like LD and UD.
No, that's what.
Yes.
You see, actually from J, they have got to be promoted to SJ, I think.
Norman.
And yes, and thereafter, maybe to that post of court master. But
Courtmaster
how
or
can both of them be the feeder post?
maybe, my lord, even then, if they have some qualification and all, many more length of service. Anyway, then my lord will see nature of appointment. Appointment to the post of courtmaster will be temporary and subject to review every year. Selection and appointment of the employees courtmaster will not be
Where are you
treated.
reading that?
Nature of appointment, my lord, at page 645.
645.
Yes. Nature of appointment. Appointment to the post of courtmaster will be temporary and subject to review every year. Selection and appointment of an employee as courtmaster will not be treated as his or her promotion. Status, gazetted 2DD, promotion. An employee from SJA cadre holding the post of courtmaster will be considered for promotion as administrative officer judicial. Then seniority of an employee holding the post of courtmaster will be maintained in the original post cadre of the employee concerned, irrespective of his or her placement in the select panel for appointment as courtmaster.
This is with regard to court master. This has
Master,
nothing
no,
to
what
do-
I'm saying is, my lord, more or less, my lord, a similar, position can be ascribed to the court officer also, protocol officer also. Because my rule is silent on that, my lord. Now, fact that it is encathered on a scale of pay which is equivalent to administrative officer judicial. And since administrative officer judicial can be filled up by my lord senior judicial assistant. So it is that analogy we're trying to draw, my lord. I'm just showing the rule position, my lord, how the rule stands. Now, as far as the present case is concerned, our basic challenge is twofold. One, respondent number 5 is not eligible. And the Honorable the Chief Justice on the administrative side, having regard to sub-article 2 of Article 229, would not have, my lord, exercise discretion when the rules speak otherwise. Rule says, sub-rule 3 says, 3A says, whoever is in so-and-so, and whoever is a law graduate, he alone can be appointed. He is neither of them. He is substantively appointed as senior judicial assistant, and my lord, he is not a graduate in law. Can Chief Justice in such a situation, my lord, take such a call? Lord, I will rely upon 2-3 judgments, my lord. First, I will rely upon one judgment of our High Court, my lord. I'll give the copies. Ah, 2001 GLT 36. My lord will kindly come to paragraph 7. 7, 8, and 9. In fact, 10 also.
Yes.
Learned counsel for the petitioner submits that service rules of the High Court is silent as to whether the post is a promotion post or a direct recruitment post. The question is to be determined from the practice followed in the outlying benches of the Guwahati High Court. Even in the principal seat, the post was filled up from amongst assistant librarian and others by selection. Here the post was librarian matter. There is no justification to have different yardstick and criteria for involvement alone. When the post was created on 6/1/92, it was bounden duty of the authority to consider the case of the petitioner for promotion, and failure to do so was arbitrary and illegal. And this was done only for the purpose of denying the petitioner right of consideration of her promotion to the post. There is no rational and lawful reason for the respondents to re-advertise the post of direct recruitment without considering the case of the petitioner for promotion. Her right to be considered for promotion has been violated. An affidavit in opposition has been filed on behalf of the respondent number 2. In paragraph 5 of the affidavit in opposition, it is stated that in the year 93 representations were considered and one MC Tiken Singh was appointed on ad hoc basis for a period of 6 months. Later on, the period was extended till 1/8/94, but thereafter it was not extended. With regard to the filling up of the post in the principal seat, it is stated that there is no instance of filling up the said post in the principal seat by promotion from assistant librarian. The post is filled up from eligible candidate to selection test interview after observing all formalities. That does not mean that the post at the principal seat has been filled up by a direct recruitment. Rather, it is the consistent practice that the post of librarian cum research officer is virtually treated as a promotional post. No doubt selection is made among the similarly situated persons in the office. A categorical statement was made that the post was filled up by a promotion and that has not been specifically denied. The other point which is highlighted in the affidavit in opposition is that Rule 63 and 63A gives wide power to the Chief Justice in matter, and in view of that, sorry. And in view of that, the decision of the Chief Justice cannot be challenged. Let us have a look at Rule 63 and 64, which are quoted below. Residuary power is quoted, my lord. Then please come to the subpoena. Said power cannot be used by the Chief Justice in an arbitrary or capricious manner, and he cannot have one practice or procedure for one outlying bench and another norm for another outlying bench. The Chief Justice is also bound by the rules, and he cannot make certain provisions applicable to one outlying bench and another provision for another outlying bench. There must be uniform procedure for all the benches. It is also not understood how beneficial it will be to the institution to have fresh recruit when experienced hand with requisite qualification is available in the institution. Further, if the prayer for promotion is not considered, it will bring frustration among the employees. As a model employer, one must always provide adequate scope for promotion in particular line of the employee. This post is transferable. Employees of Guwahati High Court belonging to one institution, and they can be transferred by Chief Justice from one place to another as provided in Rule 17A of the rules. No doubt, Rule 12 gives power to the Chief Justice to leave unfilled or hold in abeyance any vacant post in events. Supreme Court considered the power of Chief Justice under Article 229 of the Constitution in so and so. No doubt that the Chief Justice has the overall power to deal with his employees in the manner as provided by the rules, but the discretions cannot be according to the length of the foot of the chancellor. It cannot be allowed that one said Chief Justice will make one view, take one view, and another will set it at naught. This may amount to unreasonable exercise of power and may even amount to discrimination. The Advocate General, in support of his contention, places reliance on so and so. There, the appointment of BP Saikia as Registrar Inspection in Guwahati High Court was challenged by Assam Judicial Service Association. The post was created by notification dated 9/7/84, and it was sought to be added to the Assam Judicial Service post. And it was stated in the notification creating the post that necessary amendment in the Assam Judicial Service will be made in the due course. But at the time of appointment of BP Saikia, the Assam Judicial Service rule did not include the post of Registrar Inspection and Inquiry. And in exercise of the power under Article 229 of the Constitution, Chief Justice appointed the Saikia in the aforesaid post, though he was not a member of the Assam Judicial Service, as the Judicial Service rule was not amended and post was included in the High Court service in gazetted rank. Rule 6A of the rules provide as follows. All appointment to the post in the service of the High Court gazetted rank and all promotions shall be made by the Honorable Chief Justice with absolute discretion. On the basis of the said rule, it is sought to be urged by the learned Advocate General that word used absolute discretion means that the action of the Chief Justice, on the action of the Chief Justice, no challenge can be made. Regarding exercise of discretion by the authority, the law now has taken a shape in so and so. Such a discretionary power which is capable of being exercised arbitrarily is not permitted by Article 14. While Article 14 permits a reasonable classification having a reasonable nexus to the objective sought to be achieved, it does not permit the power to pick and choose arbitrarily out of the several persons falling in the same category. A transparent and objective criteria procedure has to be evolved so that the choice among the members belonging to the same class or category is based on reason, fair play, and non-arbitrariness. The use of the word absolute in Rule 6A will not give such a long handle to the Chief Justice to do anything and everything according to his pleasure by setting at naught the rules and the principles. A case has been cited by the learned Advocate General so and so, wherein it is stated that the authority is entitled to take a decision not to fill up the existing vacancies as on the relevant date. There is no quarrel about this proposition of law, but what is important in this case is that in exercise of power to issue advertisement, right of the petitioner to be considered for promotion has been violated. Well-established practice and procedure have been violated, and all future chance of promotion in that line of petitioner has been wiped out. Petitioner has a right to be considered for promotion. There is no valid reason to fill up the post by direct recruitment. No material was placed to show that by application of mine, such a decision was taken for the benefit of the establishment. No record was produced before me to show that a conscious decision was taken after due deliberation. By a stroke of a pen, a discretionary power cannot be exercised. I specifically asked the learned Advocate General what will be the benefit improvement in the institution by direct recruitment. He failed to give a convincing reply. A new hand rather may create problem. It is always better to rely on an experienced hand instead of having a man without a better. My lord, in my humble understanding, my lord, two important principles can be called out from the judge. One, right to be considered for promotion is one aspect which was recognized, which we are doing more or less similar position, my lord. There was no rules as to how to fill up the post of, librarian. The authority, Guwahati High Court Imphal Bench authority took a call that no, we will go for fresh direct recruitment. Then, my lord, the employees filed were seeking, my lord, promotion. At their instance, my lord, the judgment was written. And secondly, my lord, the exercise of discretion by the Chief Justice under Article 229(2) read with 63A, it is subject to the rules. My lord. The rules, sub-rule 3A of Rule 7 prescribes something, my lord, which the respondent number 5 with petitioner, the appellant, my lord, he does not possess. Therefore, my lord, the exercise of discretion in the manner as has been done in the instant case was not appropriate, and in our humble submission, my lord, is liable to be interfered with. My lord, the next I'll rely upon a decision of the Supreme Court, my lord. 2011 14 SCC 187. My lord, this is State of West Bengal versus Debashish Mukherjee. My lord, will kindly come to para 36. The fact that in regard to certain type of actions or orders of the Chief Justice, the scope of para 36, my lord. I think, my lord.
Yes, we'll just rise up for 2 minutes.
No problem.
Okay, so you have given us from para 36.
Yes. My lord, we're trying to save some paper, my.
Okay, no problem.
I think Guwahati High Court should introduce both side systems, Supreme Court like my.
It is being done. Orders we have, it is
No, no, my lord, even the petition, they should allow both sides.
I think it is
No,
it been allowed. I think it was allowed.
No, but like annexures are directed to be given in both sides.
Not the petition.
Meetings are doing some.
I know orders we are passing both sides.
Yes.
Orders are passing.
2 minutes.
My lord. No, no, I will have to have a. Taking over. আমি 1 নম্বর দেখতেছি। 1 নম্বর এপিসোডে সত্যি। 14 SSC 187 এটা মই একটু বিচাৰি আছো। One at seven, when is this? 2011. এবার তো কলেজ 2011 14 SCC 187 দেখো না রে না সময় आणि आणि
Yes,
My lord will kindly come to para 36.
yes.
The fact that in regard to certain types of action or orders of the Chief Justice, the scope of judicial review may be very narrow and limited is different from saying that an order of the Chief Justice granting certain relief to the High Court employee whose service conditions are governed by rule is not justiciable. Such orders are justiciable. That means, my lord, it can be subject matter of challenge. We may refer to the principles relating to the power and discretion of a Chief Justice of a High Court under Article 229(2), which reads as thus. But I'm not reading this 229(2), para 38. In exercise of the power conferred by Article 229 of the Constitution of India, Chief Justice of the High Court of Calcutta, with the approval of the Governor of the State of West Bengal, so far as rule relate to salary, allowance, leave, pension, made the Calcutta High Court Service Rule 60 with respect to appointment of persons to and to the condition of service of persons serving on the staff attached to the High Court. While Chief Justice has power to amend the rule, he does not have the power to ignore the rules. It's very important. Rule 23 of the Calcutta High Court Service Rule provides, subject to the following exceptions, the provisions of the West Bengal Service Rule, insofar as they relate to salaries, leave and allowances, shall apply to the members of the High Court Service, class so and so, as they apply to government servant of the corresponding classes in service of the government of West Bengal. Provided that the power exercisable under West Bengal Service Rule by Governor of the state shall be exercised by the Chief Justice, and power exercisable by any authority subordinate to the Governor shall be exercised by the Chief Justice or by such person or persons as by general or special order direct. In Gurumurthy versus Accountant General Assam is a case from our High Court, my lord. Article 229 contemplates full freedom to Chief Justice of the High Court in the matter of appointment of officers and servants of the High Court and their conditions of service. The unequivocal and obvious intention of the framer of the Constitution in enacting Article 229 is that in the matter of such appointment, it is Chief Justice or his nominee who is to be the supreme authority, and there can be no interference by the executive to the limited extent that it is provided in the article. Even legislature cannot abridge or modify the power conferred on Chief Justice. In the state of UP versus so-and-so constitution bench of this court, consider the dispute relating to competence of the Chief Justice of the High Court to grant advance premature increment to an employee working in the High Court. State government was of the view that Chief Justice could not grant advance premature increment without prior approval of the governor. Instead of directly challenging the Chief Justice's competence, state government refused to take into account premature increment sanctioned to the respondent by the Chief Justice of the Allahabad High Court while determining the respondent's pensionary benefit. The matter was examined with reference to one Article 229(2) and proviso thereunder, which laid down that the condition of service of officers and servants of the High Court shall be regulated by rules made by the Chief Justice, and the rules, if they relate to salaries, allowance shall require the governor's approval. Rule 3, 2 proviso to Rule 42 and proviso to Rule 41 of the Allahabad High Court Officers and Staff Condition of Service Conduct Rules 76, which provide for creation of a temporary post with the approval of the governor, applicability of the state government rules to the High Court staff with such modification, etc. As Chief Justice may specify, obtaining of the governor's approval where such modification, etc. relates to allowances, leave or pension, exercise of governor's power by Chief Justice in relation to High Court staff. 3, Rule 27 of the Financial Law, etc., etc. Para 41. Reading together the two provisos to Rule 42 of the Allahabad High Court rule, officers and so-and-so rule, this court held in C.L. Agarwal case that it was apparent that rule and orders referred to therein were rules and orders of a general nature and not orders made in individual cases. That insofar as officers and servants of the High Court were concerned, it was enough that the High Court Chief Justice exercised the power conferred upon the governor under such rules and orders of the government, and no further approval by the governor is required. The court also held that even in Rule 41, the reference was to the making of a general orders and not the orders in individual cases. The order of the Chief Justice granting premature increment did not therefore require the approval of the governor. It was held that as the Chief Justice has the power to create the post in the High Court, it was the Chief Justice who could grant the premature increment under Rule 27 of the Financial Handbook to the officers and servants of the High Court. And even if it was assumed that the advance increment under Rule 27 could be granted by the governor, Chief Justice would exercise governor's power by virtue of the second proviso to so and so. Then my lord will kindly come to para 44. It is therefore clear that the Chief Justice has the power and authority to grant premature increment in exceptional circumstances. But the Chief Justice cannot grant such relief in an irrational or arbitrary manner. If the rules provide that the premature increment could be granted in exceptional circumstances, there should be reference to the existence of exceptional circumstances and application of mind to those exceptional circumstances. When neither the recommendation considered by the Chief Justice nor the order of Chief Justice referred to any exceptional circumstances and did not even refer to the rule relating to grant of relief in exceptional circumstances, the question of assuming exceptional circumstances does not arise. The order dated is justiciable. In view of above, none of the seniors was entitled to any relief with reference to pay of their junior Gopinath Dey. We therefore allow these appeals, set aside the order of the division bench, and restore the order of the learned single judge, dismissing the writ petition. My lord, if the rule prescribed in a power to be exercised in a particular manner, Chief Justice will have to exercise in that manner. Here, my lord, there was no reference to exceptional circumstances. The Honorable Chief Justice was in fact endowed with power in exceptional circumstances to give advance increment. But since, my lord, in the decision-making process, there was no reference to the exceptional circumstances. Therefore, my lord, it was held that Chief Justice do not have any discretion as such. He has to exercise power in accordance with rule. That's why, my lord, sub-article 2 of Article 229 starts with the word subject to the rules framed in this regard. So therefore, in my humble submission, my lord, here in this case, on the face of, my lord, sub-rule 3A of Rule 7, which prescribes certain conditions, my lord, of recruitment, the Honorable the Chief Justice would not have, my lord, invoked power under 229(2) or, my lord, 63A. Thereby, my lord, our right to be considered for promotion, our career progression has been, my lord, violated. It cannot be permitted. There is one more decision on this point, my lord. Huh? Oh, so that's it. Second decision. 2011, 12 SCC 137, paragraph 32 and 33. Besides, there is no right of promotion available to an employee. He has a right to be considered for promotion, which has been held to be a fundamental right. However, though a right to be considered for promotion is a condition of service, mere chance of promotion is not, is not. The fact that the first respondent could not be considered for promotion to the post of PA in district so-and-so was undoubtedly the consequence of his transfer outside that district. However, in view of what is stated above, that itself cannot make his transfer a punitive one. As rightly stated by the then Registrar General in her affidavit before the High Court, the first respondent would be retaining his original seniority, though he was transferred in another district. He was in the cadre of Sirastadar, and he continued in that cadre in the district of so-and-so after he was transferred to that district. In district so-and-so, he was officiating as PA to the district judge. Since the post was vacant, but his substantive post was that of Sirastadar, officiating work did not create any right in him to be continued in the post of PA. That also was not his case, and this is how he has sought to be empaneled for being considered for promotion to the post of PA to district Tuticorin. Since the first respondent was no longer in district Tuticorin, obviously he would not be included in the panel prepared for consideration to the post of PA in this system. My lord, this judgment is an authority for the proposition merely for holding an officiating appointment, my lord. He does not acquire any indivisible right to continuing any post. I am referring to the judgment insofar as, my lord, the respondent number 5's appointment as protocol officer is concerned. So, my lord, in the backdrop of the factual matrix and the legal position which I have, my lord, expressed, my lord, as laid down for a lordship's kind consideration, my humble submission is, my lord, we had no legal justification to challenge the order of temporary officiating appointment of respondent number 5 as protocol officer for the simple reason, my lord, it was an officiating appointment, and he continued to be in the cadre of, my lord, senior judicial assistant. If at all he is entitled to any position, a promotion, then he will be considered from that position. I have also explained, my lord, how relying upon the Kerala module, my lord, this honorable court, the judges, 3 honorable judges committee on, my lord, March 2015 took the call on, my lord, why that provision came to be inserted. And we have also, my lord, by referring to that 2016 resolution, whereby, my lord, he was appointed as a protocol officer. Then finally, my lord, by referring to the legal position, I have clearly explained. Going by the, yes, it's a fact, my lord, there is no clear provision in the rules as to how the post of protocol officer is to be, my lord, appointed. Or
What about AOJ and court officer also? Same thing.
No, well, court officer it is, or the court master I have shown, my lord. Court officer, I have shown, my lord, that sub rule 5 of rule 7.
Court master.
Court master.
No, but court master is different. You see,
Court master is different.
court officer is in the
Not court
2C.
master, as far as court master and protocol officer is concerned, my lord, same procedure.
That's what I'm saying. So court master, court officer, and the AOJ and protocol officer, there is no clear cut
There's-
rule
there's
saying
no-
how they are to be promoted. So there's
My
nothing.
lord, assuming, my lord, it is to be either promoted or selected. A procedure which is, my lord, consistent with Article 14 and 16 will have to be followed, my lord. It can't be at the discretion of the Chief Justice.
No, so,
A procedure which is consistent with Article 14 and 16.
so where are the promotion officer orders of
Ah.
AOJs,
Okay.
court
My lord,
officers
Yes,
and this protocol officer?
my lord, they have in fact annexed an order, my lord, which is not very clear. We'll try to have a better copy and submit, my lord, tomorrow. In fact, it is their memo of appeal, my lord, at page 69.
Now, what happens in the absence of rules
Ah.
for promotion?
That's what I said, my lord. Assuming, my lord, the selection is made. Follow a procedure which is consistent with Article 14 and 16. It can't be at the cost of somebody else's right who are equally placed. And he is not even equally placed. He's junior to us. His position is at serial 49. And some of us have already become AOJ. We are not even in that cadre, we are above that, which is equivalent to the protocol officer. My lord, regarding that, when we became protocol officer, sorry, AOJ, that chart we'll give tomorrow, my lord.
Promotion orders.
Promotion orders, or the date when we became AOJ.
No, I don't want the dates. I want the promotion orders.
I think, my lord, in the other appeal, the copy is clear, my lord. Page 76. In the other 71. Page 76. Sofiqur
No,
Rahman, my lord.
these are list of dates, there's nothing.
No, my lord, AOJ, the last column.
Gradation list, that's all. No
Gradation
promotion.
list in AOJ, he is my lord serial number 20.
No, I'm not on that. I want to know
The promotion orders,
whether they have been promoted or appointed.
promoted.
So so I want to see the order.
We'll hand over, we'll suddenly. We're promoted.
Well, that is
Yes,
that is your case, that this
No,
respondent
I
number 5.
followed. Tomorrow we'll get. 2-3 sample copies will place, my lord.
Yes, not only AOJ,
Huh.
court officer, protocol officer.
No, regarding court officer, my lord, now I'll hand over the note that lordship will see. Earlier it was promotion.
Unless you give us the note, it's very difficult.
No, my lord, again, no, we have now prepared the note, my lord.
Protocol officer appointment is there, 144 and 145.
In
In writ appeal number 5.
No, he's the present one, my lord, the impugn order.
page 145.
144, 145. 145 is the secretary to the chief justice, 144 is the protocol officer.
No. I'm not on Niroj Sharma,
Some other cases.
some other case.
Yes.
Okay, some other case.
Some other cases. What was,
High Court can
you
provide-
see, one issue that has cropped up is the procedure that had been followed earlier in
Right.
2011.
Right.
Now that has been changed
From 2015,
from 2014 or 15.
15.
So now one of the issues is whether there should be a uniform procedure or whether you can keep changing the procedure as and when you want.
For the appointment of protocol officer.
For the appointment of 2C,
You see, right?
because there is no rule
Prescribe.
prescribed as to how the promotion is to be done, from which feeder post it has to be done for all three categories.
Well, so far as protocol officer is concerned, the feeder cadre is senior judicial assistant.
From where do you get that?
That is
From
there.
where does it specifically state?
Anyway, time with you.
From where does it state?
They are in the rules.
Okay, so not there in the rule. That's what, it's not there in the rule. That's
What
why.
happened is one of the judges committee. we have
That is what, that is what.
Took a decision that.
Yes,
would be the
that
matter-
is what.
My lord, in my note, I have given that, my lord, also will get them.
No, so you see, that's why we've got to be very clear on the facts.
Yes.
Uh,
In fact, lordship will have to go through the record, only 3-4 page, my lord, original record.
Anyway,
My lord will kindly come to page 173. Let us
Of-
come to the views of the learned single judge.
hold on,
Yes, impugn order, learned single judge's order.
170?
5, writ appeal 5 of 23, my
Yes.
lord. 173.
Yes, that was another question now I wanted
Yes,
to ask.
Yes, yes.
I think you have to give us the reason why your writ petition was allowed by the single judge.
That's the reason, my lord. That's what
One
page
page was-
173.
173.
Yes. Para 33. The view which the learned single judge of this honorable court had taken and the view which the honorable Supreme Court had taken in that West Bengal case. Devasis Mukherjee. That exceptional circumstance, there was no reference to exceptional circumstance in the Supreme Court case. Now, in this case, what is the reason? That is not even, my lord, discernible. Para 33.
Yes,
The aforesaid consideration in the opinion of this court, while exercising the power under Rule 63 of the rule cannot be termed as adequate. My lord, this expression adequate, it has got an connotation, my lord. It can't be construed to be a word as if it is not adequate or, no, what to say, my lord? That adequacy. That means, my lord, whether a court exercising power under judicial review can go into the extent of sufficiency of reasons.
that's what.
No,
That is one
That is
aspect.
that is not the context. The
Because,
context is, my lord.
you see, adequacy is a view taken by the authority
Yes,
and whether this court or the single judge could have substituted its views to the view taken by the
Authority.
Yes,
and in that regard, whether court can go into the sufficiency of the reasons.
correct.
Now, sufficiency and adequacy, there is a lot of difference, my lord.
No, and another aspect, whether we can substitute.
Question of substituting does not arise. The court was examining the decision-making process.
Correct.
If in the decision-making process, court notices any shortcoming, who are the rules, then, my lord, court can always interfere. That's why in Devasis Mukherjee's case, when Chief Justice exercises power under 229(2), this is justiciable, meaning thereby this is amenable to challenge.
No, that is all right.
Yes.
Anyway,
Now let us read, my lord.
this word is-
Other than merely stating earlier precedents of Soilendra Chaudhary, there is absolutely no discussion regarding relaxation of mandatory requirement of incumbent to have a LLB degree. At this stage, the original records produced reveal that Soilendra Chaudhary, the earlier incumbent, was a class 2B officer who was well versed with stenography and typing, and this aspect played a very important role in the appointment of as secretary to CJI. As per the rule, a post of class 2B is a feeder post for secretary to the honorable CJ. In contradistinction, respondent number 5 does not possess any such qualification, and therefore the case of Sholendra Chaudhary could not have been cited as a precedent. But this is a view which has been taken by the learned single judge. Is this view so unreasonable that the learned single judge could not have taken? And in an intra-court appeal, would your lordship substitute this view of the learned single judge?
There's another aspect to this. Is the view of the Chief Justice
Hmm.
while exercising his discretion.
Is so unreasonable. It is.
No,
It is, my lord.
that is the issue also.
No, it
You
is.
see, no, that is naturally, you'll
Well,
take
If
that.
this view would have been taken by Chief Secretary of the state, then lordship would have
You
clearly
see,
said, this
you
is
see,
unreasonable.
that same argument will hold
No,
good.
my
also.
lord.
We have to balance all the arguments and the views.
Anyway, at 2 o'clock. my lord.
Yes. I think 2 o'clock. But then I don't know, we have got some other, I think 2 o'clock.
And I'll not take long, my lord. I'll another 10-15 minutes, I'll conclude. Done, thank you. No, my lord. से पास करा लेवल के जो बेलेग दोनों $73 my lord. Para 33.
Yes.
The aforesaid considerations in the opinion of this court, while exercising the power under Rule 63A of the rules, cannot be termed to be adequate. Other than merely stating the earlier precedents of Sholendra Chaudhary, there is absolutely no discussion regarding relaxation of the mandatory requirement of the incumbent to have an LLB degree. At this stage, the original records produced reveal that Sholendra Chaudhary, the earlier incumbent, was a Class 2B officer who was well versed with stenography and typing, and this aspect played an important role in his appointment as a secretary to the Honorable Chief Justice. As per rule, a post of Class 2B is a feeder post for the secretary to the Honorable Chief Justice. In distinction, the respondent on 5 does not possess any such qualification, and therefore the case of Sholendra Chaudhary could not have been cited as a precedent. There is absolutely no doubt in mind of this court that relaxation power had been vested upon Honorable CJI for relaxing age or qualification of an incumbent. But whether such discretionary power can be exercised to do away with essential qualification is a debatable issue. However, assuming that even a requirement which is mandatory in nature can be relaxed, there should be adequate discussion to show that there was application of mind to do away with such a requirement. My lord, I'll humbly pause here for a moment, my lord. The expression adequate as finds place in second sentence, and my lord, in the last but one sentence of this page 173 makes the position clear. What the Honorable Learned Single Judge, took the view was, towards giving that, my lord, relaxation, there is requirement of some, consideration, relevant consideration, which was not found to be adequate in the sense, my lord, there was shortcomings in the decision-making process. What is that shortcoming? There was more discussion ought to have been there, my lord, in the sense, my lord, end of the day, my lord, if a satisfaction is to be arrived at by an authority, even if it is an subjective satisfaction, my lord, my humble submission is it must be based on some objective material. Now, it is those objective materials which were missing, my lord. That is what the Learned Single Judge meant by saying when he refers to the expression adequate. Because end of the day, my lord, why do we say there is a requirement of giving reasons in an order? The requirement of giving reasons in an order is obvious. Number one, my lord, it obviates arbitrariness in the decision making. It brings in clarity in the decision making process. And thirdly, my lord, most importantly, an aggrieved person would know the reason why his case has been rejected. In which event he would be in a position to, my lord, file an appeal saying that this ground is good or that ground is bad. Now, in the absence of any reason, my lord, how is it possible to justify, my lord? End of the day, it is also violative of natural justice. If an order which I want to assail is, my lord, unintelligible, in which case, my lord, is my right under Article 14 read with natural justice is not violated? Because I don't even know the reason. That is why, my lord, this expression adequate has to be understood in the context in which it is made. It is not an expression to take the view that learned single judge was going to the adequacy of the materials. No. What learned single judge meant was, my lord, that the required materials were not there. There's a difference between required materials and adequate materials. A perusal of the file notings, however, do not show any such application. As observed above, the case of Shailendra Chaudhary is not similar. Now, my lord, this is the most important paragraph in the whole judgment. Now, my lord, Lordship has noticed the single judge judgment from Infowile, this Honorable Court considering the Imphal case and Depaji Mukherjee's case from the Supreme Court. There also, the Honorable Supreme Court emphasized that in an exceptional circumstances, Honorable Chief Justice has the power to give relaxation. But while giving relaxation, my lord, that exceptional circumstance must appear from the decision-making process. If the exceptional circumstance is not evident, my lord, then, my lord, the exercise of power would be bad. Similarly, in this case, my lord, he is all right, my lord. There is some debate as to how, in what process it would be filled up. But admittedly, he is not a graduate in LLB. He is not an LLB graduate. So, my lord, there has to be some finding, some reasoning given as to why the Honorable Chief Justice was, my lord, dispensing with the requirement of LLB. How his other qualifications, how his other, my lord, the qualities would help him in discharging his functions. There must be something, my lord. It can't be in thin air that a decision will be, a discretionary power will be exercised. Therefore, in my humble submission, my lord, the view taken by the learned single judge in para 33 of the judgment, in our humble submission, subject to what your lordship may say, my lord, is absolutely rational, my lord, and it does not call for any interference. Moreover, my lord, the view which has been taken, this is one possible view. Merely because, my lord, there is another view, would a writ appellate court substitute that view, my lord? The other view may be possible in the facts of the case or in a given facts of a case. But whether that lordship will do that, I'll place that judgment which your lordship will normally not do. This court, then para 34. This court is also
Mr. Kelsey, how much time will you take?
another 5 minutes.
I've got single bench on.
I know, another 5 minutes. I'll conclude. Otherwise, I'll be repeating the same thing, my lord. This is in substance my argument. This court is also of the opinion that the power vested by Rule 63A, which is discretionary in nature, has to be exercised in reasonable manner and for a situation of necessity. There was no dearth of eligible candidates in the feeder cadre having requisite mandatory qualification to be considered for the post of secretary to the Honorable Chief Justice. When there were a number of eligible candidates, there was no occasion at all to take recourse to a relaxation power under Rule 63A to give a benefit to respondent number 5, who is otherwise not qualified to be appointed as secretary. Well, how this view can be faulted, my lord? View at page 34. I can appreciate, my lord, in a case where people with eligible, adequate requirements or the requisite qualifications are not available in the zone of consideration. In such a scenario, my lord, if the Honorable Chief Justice exercises discretionary power, it is understandable. For example, I can give one example, readily I don't remember the citation. When state of Haryana was carved out of state of Punjab, my lord, state of Haryana framed their own rules. I think it was a case of engineering department, I think from promotion from executive engineer to superintending engineer, where, my lord, the required qualifying services were not there. The government invoked the relaxation power and promoted persons. Well, some people challenged those decisions. Supreme Court said when people are not there, when there is a necessity of the hands, then relaxation of power is exercised. What is wrong in it? Like one can appreciate, my lord, but if we read para 33 harmoniously with 34, the view of the learned single judge is clear and loud. One, he is not there, not having LLB degree. It's not that there were other people who were not there. There are adequate number of people were there who had the requisite qualification. In that view of the matter, this learned single judge has taken the view that the decision was wrong. Now, my lord, I'll just place that judgment, my lord. It will be okay. My lord, this is 2004 1 GLT 117. I think para 26, my lord. Para 26. While dealing with the present appeal, one has to bear in mind that a writ appeal is really not a statutory appeal preferred against the judgment and order of an inferior court to the superior court. The appeal inter se in a high court from one court to another is really an appeal from one coordinate bench to another coordinate bench. And it is for this reason that a writ cannot be issued by one bench of the High Court to another bench of the High Court. Nor can even the Supreme Court issue a writ to the High Court. Thus, unlike an appeal in general, a writ appeal is an appeal on principle. And that is why, unlike an appeal in an ordinary sense, such as a criminal appeal where the whole evidence on record is examined anew by the appellate court, what is really examined in this appeal is the legality and validity of the judgment or the order of the learned single judge. And it can be set aside or should be set aside only when there is a patent error on the face of the record or the judgment is against the established or settled principle of law. If two views are possible and a view which is reasonable and logical has been adopted by the learned single judge, the other view, howsoever appealing such a view may be to the division bench, it is the view adopted by the single judge which should normally be allowed to be prevailed. Hence, the impugned judgment of the learned single judge cannot be completely ignored, and this court has to consider the judgment in its proper perspective. And if this bench sitting as an appellate bench is of the view that decision arrived at by the learned single judge, without any material error of fact of law, then judgment in question should be allowed to prevail. Reference and so, my lord, in my humble submission, the view which has been taken by the learned single judge under the facts and circumstances of the case is a possible view, my lord. It does not suffer from any perversity. It's not a view which could not have been taken. Of course, my lord, another view is possible to be taken on the same facts. So, your lordships exercising power of the intra-court appeal, whether your lordships will substitute that view. The settled principle is, my lord, normally lordships will know. Now, here in this case, my lord, an incumbent who does not possess the requisite qualification has been appointed. He has been interfered with by the learned single judge on the reasoning that the reason given by the Chief Justice for invoking power under 63A falls short of the requirement. And secondly, it is not that other people are not there in the zone of consideration to resort to this extraordinary power. It is an extraordinary power, my lord. It is not a power which can be exercised off and on. So when other people were there, were in the zone of consideration, where others had the requisite qualification, whether there was any necessity to resort to such a power. So these are the basic two views based on which my lord impugned judgment has been taken. In my humble submission, my lord, this judgment does not call for any interference, and lordships will dismiss both the appeals. That's my humble submission. Lordship's kind permission. Can I take leave, madam? Deep breath. Yes.
What I find from the argument advanced by my learned friend in the other side. Their basic question they are raising is first that my client was not appointed.
Yes.
Substantively
Was not promoted.
promoted. Well, first question is whether my appointment to the post of protocol officer. Therefrom I come. Therefrom I climb up. Fact is-
Their basic case is that the post, the class 2C post is a promotional post. However, you have been appointed, not promoted. That, otherwise,
No.
if it was a promotion, you would not even have come within the consideration zone. That is the case.
Well, for that, Lordship will see what is the provision? Is there any provision in the rules? Is there any provision in the rules for filling up the post of protocol officer? There is nothing. There is nothing. But there is an established procedure by way of a resolution taken by judges committee of the
Resolution dated,
state. Resolution procedure, no? Yes. My let friend speak.
There is no rules saying that the protocol officer can be appointed in. Terms of appointment in the appointment order committee. With the
actually, we had allowed Mr. K. N. Chaudhary to go, we should not have allowed, because I'm just thinking, now the questions will start coming up.
Well, those were placed before the marriage signatures also. My learned friend was there also. And when the case was placed on behalf of the Honorable High Court by my friend Mr. Nair, then also it was placed. It was argued. He knows about it.
Just give me the date of the resolution. That is what. Now, what Mr. K. N. Chaudhary was referring to was was a resolution passed in the year 2011. Where there was a promotion made to the said post. After having a set of 5-6 people who are within the zone of consideration going through a process of interview. So what he implies is that there was a promotional process in place and there was a promotion that had taken place earlier. Now, by way of the subsequent resolution made in 2014, there has been change in the manner of filling up the set post of protocol officer, which cannot be done.
Well,
That is one of the first
one
issues
letter
that
of-
you will have to answer.
well, my respectful submission.
That is what I wish he was there also, you know. So
Well,
that when you answer, I can put a counter question to him also.
Yes. Now, let the subject to what it will be argued on behalf of this honorable court. My response to the argument that was advanced,
Yes,
that has come through your object.
yes, yes.
Look, this has no substance at this point of time. Because this post was filled up by adopting a process which was never put to challenge by them. Kindly see the advertisement at page 117, 143.
Page 143.
Yes,
Five, readable five.
readable 5. I am not aware about what was done earlier to this particular post. Let us go from this advertisement.
No, but then
Well,
you might
I-
not be aware, but
No,
we
no,
have got to go into that.
What I mean to argue
Ha.
that let us go from this.
Okay,
And if there is any relevance to its past,
okay, page,
page 143. Relevancy of the past will be dug out if necessary, otherwise not.
Page 143.
143.
Yes.
This was a notice issued on 2nd of September 2016. Options are hereby invited. Can you see? Options are hereby invited from the intending senior judicial assistant of this registry for filling up of one vacant post of protocol officer in the principal seat of the High Court in the pay band so and so plus grade pay of so and so plus other allowances as admissible under the rules. Preference will be given to those senior judicial assistants who have completed 5 years of service. Now pausing for a moment here, but without going to the other part. Does it say anywhere that this is a promotional post, we are making a promotion? No. Impression that one will get from this advertisement is that this is a post to be filled up directly. Direct appointee from within the house. This is a post to be filled up not by way of promotion, but by way of direct recruitment. In-house, within the registry. That is a vacant sanctioned post. The registry wants to fill it up from amongst its house members. And for that, options must be given. Those who want to go to that post, they may apply and the selection will be
But
made.
please read this second paragraph.
Yes, now let us come to the second paragraph. Second paragraph says the selected candidate for the post of protocol officer will maintain her seniority in the original cadre and her further promotion.
Further promotion.
Further
Further
promotion.
That word. Further
Yes, if
promotion.
at all, my lord, what we have to understand, this is not promotion, but in case of his promotion, further promotion. To my understanding, my lord, kindly see. If you want to come, I have been given a choice that look, here is a post which is slightly higher grade. But this is not my channel. I cannot come from my post by following the channel of promotion to that post. I cannot come. I am the senior judicial assistant here. There is a post protocol officer slightly higher than me, the present position I am holding. I cannot go to that. My promotional channel is somewhere there. And going by a round, thereafter I may at time come to that. This is another issue. But this is not a direct row. Now, since the registry wants that it should be filled up now, option is required. Otherwise, there would not have been a question of option. Had it been a question of promotion, the promotional rules could have been followed. Therefore, I understand that this is a post which is filled up by direct recruitment in-house. But it indicates that in case of your further promotion, if you want to go up above from that, in that case, your seniority will be counted, considered on that basis. Further promotion will be considered on that basis. Original cadre. My lord, that by itself, it cannot be in my respect assumption construed that this is a promotional post because of that further promotion.
Okay, if it is not a promotional post.
Yeah.
Then once you go into that post which is not your promotional post,
Right.
can you be promoted from there on?
If law provides for, yes. If rules provides for, yes. If not, of course, I'm stuck up there. Can this is two situations, my lord. Here, that particular paragraph, second paragraph, let us read it once more. What it says, the selected candidate for the post of protocol officer will maintain her seniority in the original cadre. Where from? Well, another question comes, obviously, when the lordship has put that question. Obviously, if I am taken there, direct appointee in that post, again.
But where does the rule say that there will be direct appointment? Supposing we say that the rule does not say that there will be promotion to the post of protocol
Protocol
officer. Does it say that the post will be filled up by direct recruitment?
Direct recruitment, that is what I said, but by, on the basis of a resolution that was taken by this honorable court at this committee, on which basis this procedure was.
No, that is where Agreed. Now you are saying 2014 resolution taken by the judges committee that it will be filled up by taking options. But then what you are saying was with regard to 2011 resolution.
Never put.
Huh?
It was done thereafter, and it was never put. It was this.
Anyway, but there are two options now.
No, in that state, it was promotion from the post of assistant protocol officer to protocol officer.
Okay.
In that case, protocol officer will come in from the senior judicial instance. But this was subsequently done away with, and might not, it was said.
From
that
senior and judicial assistant work.
Senior judicial assistant protocol officer, junior judicial assistant protocol officer, from assistant protocol officer promotion to minor protocol officer. That was in 2011 resolution, but they were not getting people. So what they did subsequently, madam, for that reason, the committee said, we will invite options for the post of assistant protocol officer from judicial assistant and for the post of protocol officer from the post of senior judicial. Anybody can apply. So madam, if anybody can apply, then there is a selection. It cannot be a promotion. The promotion, madam, those 1:5, 1:10 will not come. That's exactly what is there, what has happened. But a rider was put in that they will maintain their seniority and further promotional avenues. In because there is no promotional avenue to this post or from this post. That's what is there. But till they are there, why not? They are, but when they are senior judicial assistant, they are not getting. Moment they become a protocol officer, they are gazetted officer and given that scale of pay with all points attached. Even court master.
Now for court masters,
I'm clarifying, even court masters, when they are select, that's also option. It's not a promotion. It's an option. They are appointed and they continue as such. Even a junior can come up and become a court master, subject to that merit being assessed by the committee. And they will continue as court masters, but my lord. they are
no, you
not
mean
the-
court officer, you mean court
Court
officer.
officer is a different thing. There is a direct recruitment to that post. That's prescribed. That doesn't, court master,
Are you sure?
yes,
I doubt.
I'll show that.
Please look at the 67 rule 7(4).
Schedule 1 664. Court master in class 2 DD and court officer is in class 2C.
Correct. Now, that's what he said that it's not there. It is there. Look at 7(4). What does 7(4) say?
7(4) or 7(5).
7(4).
And court people. No, schedule of something. 664. 665.
Court officer is 2C.
I know.
I'm just giving.
And court master is 4.
Very good. I'm just-
Court officer is. He's not pay, different rate to be. Rate pay. Rate pay to. 11,000%.
My lord,
It is not 7(4). It is somewhere else I have read.
646.
It's for the-
Well, I'm sorry to interrupt. I've got some copies, my lord, where senior judicial assistants were promoted, my lord, as administrative officer.
I don't think I paid 646.
Yes,
Fine.
yes,
For the post of court officer number 2,
yes.
ex-cadet gazetted, mentioned in schedule 1, the candidate shall have to be a retired army, Indian commission officer or ex-serviceman with minimum qualification of a pre-university or its equivalent. Court officer is reversed. It's not equivalent to court master's work. And I'll get that.
There is something else.
Not coming before,
It's not coming here, it's somewhere.
Yes, ma'am, I got it. I think I placed it for what you want to last. I'll place that.
Okay, so Mr. Mahanta is saying. That this is not a promotional post.
Yes.
It is a post to be filled up by direct recruitment
From in-house.
from in-house. By way of calling for options.
Options.
Then interview by a committee. Cooking manner is simply procedure that has been followed even till the other day when they matter. Somebody was 2021 also murder. This was
Followed by resolution dated
25/7/2014.
25/7/2014. Now, according to Mr. Ken Chowdhury, the earlier resolution was dated 2011.
Gotcha.
Dated?
Yes. It is dated. Amitabh Roy, Chairman.
My lord, regarding my lord.
Promotion.
Oh,
Where
yes.
zone of consideration,
Huh.
2011.
It was 24/9/11, my lord. No, not sorry, my lord. 11/6/11. Eleven, 6/2011. In that note I have given, it is there.
Point number 3.
Yes.
So one of the question that arises is whether the latest resolution should be followed or what. So tomorrow, supposing we say, the judges committee says, we are going to do it by way of promotion.
Then it will have a promotion. Because that would be an executive instruction. In absence of a provision, the rule, that will hold the weight. Subject to somebody challenging.
So in that context, my lord,
Yes,
I raised the question
yes.
that they having not challenged this appointment or the advertisement notice,
11,600. It's. Yeah.
they now cannot urge that there is a separate procedure prevailing prior to 2014, and that should have been followed. So it is being inconsistent with that, the subsequent advertisement or the notice equipment is not proper or illegal.
So advertisement not challenged. What else was not challenged?
This notice of inviting,
2016 not challenged.
yes, 29/2016,
And the promotion appointment order not challenged.
appointment order was also not challenged.
Appointment order dated
Appointment order dated 25/11/16
as
one
as
double
PO.
as protocol officer was also not challenged. So therefore, while as per submission is that leg of argument, that there was something else in 2011. Something was decided, but as has come out now, that didn't materialize. That didn't get good result. That was not materialized because it was found to be not practical. Nobody turned up. And therefore this was abandoned. That the necessity arose for this honorable court to have a look into it and take a fresh decision. Call was taken, and 2014 the decision was taken to fill it up by inviting options and to fill up the post directly in-house. That's how, and that is having been accepted. Now, today, it is not open for them to challenge it on that ground, according to 2011, which was abandoned, apparently, for some good reason. Yes. So, they are now precluded from assailing this notification and having not challenged my appointment as protocol officer also, that is fine. The question remains, madam, in that notification itself, Lordship has already looked into an effort to me also, the second para, which says that selected candidate for the post of protocol officer will maintain his or her seniority in the original cadre. In his original cadre means my senior judicial assistant. That is the question now. And his her further promotion will be considered on that basis. That means if the question of promotion comes in future, then my promotion may be in the line in which I was there originally. That was the indication that in the line of my senior judicial assistant, in that line. Well, this is the clue on the basis of which the argument is now raised, or the learned single judge has also decided that this is a temporary affair. Whether this construction is just and legal, this is the question. In my appointment order also, this clause was there.
Temporary appointment.
No, it says simply that my seniority, kindly see this, page 144, my appointment letter. Fine. I have been appointed.
Temporarily.
This is to appoint temporarily. What temporary is used? My lordship is well versed with such appointment letters. In almost all appointment letters, temporary word is normally used. But it has to be seen how the appointment was made, under what context the appointment was made, what was the position of the post at that time, whether it was made by following a due process of law, by due advertisement, by due selection, whether those were there or not. Only on the basis of those considerations, ultimately, the final call will be taken whether this was a temporary post or a substantive. the question is, well, therefore, though this temporary word is used, it has no significance, much significance, unless one can show that it was really temporary, going by the nature of recruitment. But then here, they have not claimed on that. It is temporary because of the nature of appointment. No. Their argument is on the last 2 lines of my appointment letter, as is reflected in the advertisement, second para, here also it says, so and so will maintain his seniority in his original cadre. That is senior judicial assistant, and her further promotion will be considered on that basis. Pausing for a moment here, my lord, why was it necessary? Now the explanation has come from the side of this honorable court that this was a substantive appointment. Authorities who have made the appointment, they have explained the position.
Where have they said substantive appointment?
Appointment was substantive in the nature. That is what is the explanation given by the Honorable High Court. In their affidavit also they have said this. If it's from media, kindly see the affidavit.
There's one thing. You see, when you see this appointment order and even the advertisement, it says that so and so will maintain his seniority in his original cadre and his further promotion will be considered on that basis. Now, when you say further promotion, it means that he has been promoted. Further means a subsequent promotion. If it was only promotion, then okay, that's a different thing. But will this word further promotion mean to say that he has been promoted as PO?
Can we look at in another way, that though he has become, by now, this order, he become the secretary.
Huh?
By this order, it is in September 2018.
Yes.
He has become the secretary now.
No, but not that. I'm on page 144.
Lordship, interpretation that may be an interpretation. Further promotion means that is already a promotion, then you have further promotion. That is, of course, in bilateral submission will be misplaced in the sense that if I am already promoted to the post of protocol officer, then in my original cadre, further promotion, nothing to do with it. It is obsolete. Because I have already gone up, then again to come back and then again take a leap from here. That cannot be called a further promotion. That cannot be called a further promotion. And to my understanding, Maharaj, since the explanation has come, my argument before the learned civil judge was that probably the honorable court visualized the situation that the protocol officer post is a single post. A single cadre post that we call. 2 posts.
Now,
Now 2 posts, 1 assistant and
2 protocol officer, 1 assistant.
yes, 1 assistant protocol officer. Right. Now 4. 2 assistant protocol officer, 2 protocol officer. So that protocol officer's post, there is no further promotional avenue. And therefore, or a person who has been appointed as a protocol officer may tomorrow appear to be not exactly fitting in. He might be reverted back.
But then once he's promoted, can he be reverted back?
Question is
If
that.
it is a substantive.
That is why, my lord, it is not a promotion, as we understand from that particular clause, that particular condition put. If it is not a promotion, this is only an appointment out of course, out of turn, in the sense that he has not followed the promotional channel. He has been brought in directly there by way of selection, no doubt, but he failed to meet the requirements there. Authority is not satisfied, then in that case, he will be sent back to his original. That would not be claimed as a demotion. Otherwise, it would be a case of demotion again. Therefore, to my understanding, that was the argument we advanced before the single judge, that therefore, probably the honorable court thought it proper that that option should be left, that channel should be kept open if at the point of time there is a requirement to replace him because of some deficiency, then he may be sent back to his original cadre, and then he will take the call for further promotion in that line. But unless that happens, that contingency comes, probably he holds the post substantively. And that is what has been explained by the authorities, that yes, he was appointed substantively, and he was holding it as a substantive appointment. And going by the process of recruitment, whole process of recruitment, if we see, there was an option given, notification was published, all interested eligible candidates who wanted to go to that post, they gave their options. There was a selection, and thereupon the appointment was made. Post was permanent post. If we go by that, then there can be no two option, no two opinion to say that it was a temporary. It was a substantive appointment. Balasubramanian's case is very clear.
That we had submitted the copies of judgments earlier, but it could be here, I don't know.
Yes, yes.
Yes, if also give me the file, I can sort it.
Bundle of papers.
Acha, how long will you take, Mr. Man?
It take time, man.
Huh?
It will take time, we have to so many things.
You'll take time.
Well,
Some time will be taken,
How much time will you take?
40 minutes minimum.
45 minutes, at least, to show the judgments. We'll be showing the judgment on the points.
Pass out the points, Malad. Don't
Just on the
the
points.
points. Malad, I.
And Mr. You can have, you won't be taking much time. What? You have to.
Half an hour.
He's half an hour. He's half an hour ago.
I think we have to go through a lot of the resolutions.
I'll plan.
Lucky, my friend.
Made a list, I'll place it.
It's not about nothing. I've got a single thing. Oh, that is the problem. Yeah.
Lordship, today, my lord, lordship, allow the.
We have given you time from, I think from 11:30 or so, you'll have taken about time.
Not so the closing still.
We'll just show the judgment, my lord, just there.
Let it, otherwise, today Lordship has the single bench. If Lordship take up it tomorrow,
There's morning first.
morning first attempt, we can finish it within first.
Now, tomorrow already list must have come out. Wednesday, so list is already out.
Yes.
So we cannot change the list.
Or day after tomorrow, Malad. So that we can finish.
Thursday, we can try.
Thursday, we can try. It is always better, Malad, when the mind is fresh. It is easier.
Already has my permissions, one of the earlier, I think, one of the. Taken it, one of the dictated that also.
Lordship has already taken note of all that.
No, but then when all the legal luminaries of the Guwahati High Court come to, whoever starts speaking, we are like the willow. We sway as the wind blows.
Well, today, if Lordship allow that, my lord, just on substantive appointment, one judgment, if you Lordship can see.
That point,
That point, my lord, only, we are still having 10 minutes to be treated.
You have got 10 minutes. I don't have that time. The thing is that I think I saw that your case only that poop thing is there. Yes. Poop, yeah, that poop is there. Waiting, I know. That poop is there, then there's another review.
Problem maker.
Huh?
Problem maker.
No, his writ petition was allowed. Somebody challenged on facts. That is the problem.
Now they have come.
anyhow, Malad, we'll be closing by 5 minutes, then.
Okay. So you can do
Only,
till,
only today,
you can do till 3 o'clock. After that, I think we'll close.
yes.
No time.
Malad,
Has your Lordship got the judgments there? Or otherwise I can sort it out. It's there, I suppose.
I think so. It should be there. What is the judgment? Just tell me.
It's Balesar das, my lord.
No, citation.
Citation is, my lord, 1984 SSC 226.
1984,
1980
80
4 SSC
for FCC.
226.
Para
Para number 929 31 32.
929, 39.
929 31 and 32.
31, 32. 9, 29, 31, 32.
My lord. Just keep
Just
paragraph.
let me look, just let me look. 1980.
Name of-
1980.
Has your lordship got it? It's there.
Yes, it is here.
It is there, my lord.
Paragraph 9.
Yes,
Is it?
if I can read the paragraph 9, my lord. So the order of appointment to the service, had your lordship got it?
Yes, sir.
Is page 41 of that bunch. The page number is given in a bold letter. At the
No,
top.
sorry, not in my copy. Acha, okay, yes. 49, yes.
41. This, has your lordship got this copy having page number in bold size?
Yes, yes. Yes,
Paragraph 9, my lord.
yes,
So the order of appointment,
on the service.
Yeah. so the order of appointment to the service is decisive of seniority, and the service horoscope of each assistant engineer has to be cast with reference to his appointment order. The next question then is, when is an engineer appointed to the service? When, under the rules, he becomes a member of the service. For until he gains entry into the service, he cannot claim to be appointed to it. To hover around which prospects of entry is not the same as actual entry. Therefore, we have to examine when an engineer becomes a member of the service under the rules. Clause B, Rule 3 defines member of service to mean a government servant appointed in a substantive capacity under the provisions of these rules to a post in the cadre of service. What then if the is the cadre of service? What do we mean by appointment in a substantive capacity to a post in the cadre? Can there be a temporary post included in the cadre? Here, Rule 4 becomes relevant. Rule 4 prescribes the sanction strength of the cadre. It provides that government may, subject to the provisions of Rule 40 of the Civil Service Classification, Control and Appeal Rules 1930, increases the cadre by creating permanent or temporary posts from time to time as may be found necessary. So a cadre post can be permanent or temporary, and if an engineer were appointed substantively to a temporary or a permanent post, he becomes the member of the service. The touchstone then is the substantive capacity of the appointment. Here we get into the service jargon, which slippery semantics and flavored officialist. Then my lord will kindly, lordship has kindly appreciate that the touchstone as per the Honorable Supreme Court is to find out whether it is a substantive appointment. The lordship, the touchstone is then the substantive capacity, whether that particular person was rendering his service in substantive capacity or in a stopgap arrangement. Here the Honorable Supreme Court, my lord,
Look out here, here, para 9.
my lord,
There was a rule.
here is also a rule. In our rules, it is in schedule, the strength of the cadre, it is mentioned.
Post is permanent.
Post is permanent. Supreme Court says even temporary post can be included in the cadre.
Then also appointment may be.
Then also appointment may be substantive. The touchstone is whether he rendered the service in substantive capacity or an officiating basis. My lord, here are explanation, I am coming to it, my lord, which says, my lord, what is stopgap arrangement? Suppose the person takes a long leave for 3 months, and the another person is given a charge that by until he comes back, you look into this job. This is stopgap arrangement. He does not get a pay scale of that person for that 3 months. He will get a pay scale of his original post. Here is selection, different pay scale. Till the moment he is there as a substantive, he is a protocol officer, he is working in a substantive capacity, in a substantive post. Had it been a stopgap arrangement, there would not have been an interview, publications of advertisement notification. It would not have been there. Kindly see the next post. Next point, my lord, if I
Let me ask one thing with regard to when options are called. Is it called only from the SJ or from the J also?
No, SJ, senior judicial assistant,
Protocol officer will be from S,
SJ,
and assistant protocol officer will be from J.
SJ. Now, my lord, may I take, may I read the 29, paragraph 29. Substantive capacity is a flexible expression which cannot be frozen by current officials, nor by the conditions that obtained in the remote past when the rule was framed. On the contrary, its meaning must be consistent with Article 16 and must avoid the pitfalls of arbitrariness and irrational injustice. So viewed, we hold that the appointment need not necessarily to be a permanent post. It is sufficient even if it is to a temporary post of long duration. I worked there for more than 2 years as a protocol officer. In a department which has permanent post and temporary post of a quasi-permanent nature, there is not much to distinguish the quality of service as between the two. Patwardhan case and Chauhan case have primarily or in passing clarified the equal value of officiating service. In Patwardhan case, Justice Chandrasur, as then he was, observed in the course of discussion. Now, my lord, if I can come to the last page, the last paragraph of this page, my lord. These things are not, above things are not necessary. Paragraph 31 is necessary, my lord. No, above the paragraph 31, above the paragraph, the paragraph started with, of course, an appointee to a permanent post acquires certain rights which one who fills a temporary post cannot claim. Nevertheless, when the post is not purely temporary or an ad hoc or of short duration or of an advantageous nature, the holder of such temporary post cannot be degraded to the position of one who by accident of circumstance or for a fugitive tenure occupies the temporary post for a fleeting term. We must make this distinction not only to the facts of service life, but also to the justice to those who have otherwise rendered long and satisfactory work in the irrigation department. In short, while you do make a distinction between permanent and temporary post, when we come to the dimension of mere seniority, we whittle down the difference considerably. A post of short duration, say of a few months, is different from another which is terminologically temporary, but is kept on for 10 or more years under the head temporary.
You won't finish.
No, my lord, kindly see the next paragraph.
Okay.
But the last line, my lord, temporary or budgetary so and so.
Ah.
Those who are appointed and hold temporary posts and the later category are also members of the service, provided they have been appointed substantively to that temporary post. What in the context is a substantive capacity vis-a-vis an appointment to a post? In our view, the emphasis imparted by the adjective substantive is that a thing is substantive if it is an essential part of constituent or relating to which is what is essential. Now, my lord, coming down of this particular paragraph, the sentence starting with the word to approximate to the official diction used in this connection, we may well say that a person is said to hold a post in substantive capacity when he holds it for an indefinite period, especially for a long duration, in contradistinction to a person who holds it for a definite or temporary period or holds it on the probation subject to confirmation. 32. This is very important. Once we understand substantive capacity in above sense, we may be able to rationalize the situation. If the appointment is to a post and the capacity in which the appointment is made is of indefinite duration, if the Public Service Commission has been consulted and has approved, if the test prescribed have been taken and passed, if probation has been approved, one may well say that the post was held by the incumbent in a substantive capacity. Here, my lord, all the procedure, actually there is no procedure prescribed by the rules, but what has been followed to appoint a protocol officer as per the resolution of the Honorable Judges Committee has been followed. If there is any loopholes in the Judges Committee's resolution, that should have been placed before the course under challenge. Since it was not challenged, that holds the field.
So, my lord, on that Balashindas's case, the principle laid down by the apex court. The great petitioner, my client. I mean, the respondent there, now here the appellant. Having been so appointed as a protocol officer for indefinite period. That too by following the process which was holding the field on that day. Notwithstanding the particular clause mentioned there, I hold it substantively. And that was a substantive appointment. Therefore, the explanation coming forth from the registry of this honorable court in my respectful submission is just and appropriate.
What about that aspect that he is not a LLB?
Sorry.
LLB.
Well, that will come to the next. For that post of PO,
No.
LLB is not required. It was not a requirement for the post of PO.
For post of peer not required.
Not required.
Not required.
But for the post of
For
secretary.
the secretary only.
It is required.
That was not a subject.
That was subsequently done, relaxed.
Relaxed by whom?
By the
I
government.
will come to it.
It's there in the example.
Judgment
Today,
is-
Lordship, we kindly take note of that. My argument is that this is a substantive appointment, the very nature itself shows that this is a substantive appointment. I had held the post substantively, so long I was there holding the post of protocol. And having not realized it, probably they have not challenged it. So it remained unchallenged. The next portion I will deal with well on Thursday. Whether my next appointment would have been said to be illegal.
It won't be that simple.
It's a simple, it's very simple.
We'll wait for it to come. There's no point. It'll be simple today, but you will not complete it anyway today.
One of my case would be, once he is there, one of the court master, that was taken from the court master's thing. Once he is appointed there, till the time he remains, he is a member of Equal Service 2. 2C. If he is a member of Equal Service 2C,
I meant,
then my lord, he can be placed before the chief justice. Then it's the chief justice heading who he is. Simple as that. That will only.
That
be
is the
matter.
only questions to be determined. Whether chief justice has that authority to choose his secretary or not.
Because my lord, here, my lord is only getting caught up between protocol. Protocol officer, that is only to see whether my lord, my name also could have come within the job for placing before the chief justice. There is no selection by the chief justice. It is his own decision. And my lord, records are there. He has,
You mentioned it
everybody's name was placed.
so that's why, my lord, we'll come to it and explain it to it, our view, in our respectful submission. There is no illegality committed,
And both these. posts,
and
my
the
lord,
lordship will find,
it's very difficult to get people.
lordship will
It's not
find,
a 10 to 5 job.
even most of these petitioners, they lack the
Yes, this is important.
locus to
challenge.
challenge, because they were not qualified at that time, wearing only two.
Only two writ petitioners were qualified to challenge.
Otherwise, others were not qualified on that day.
We'll see, we'll see
Yeah.
on that.
That's
But
why
we will finish.
we'll finish,
We'll find an additional affidavit bringing
Lordship will-
those facts on record.
not necessary now.
All right.
What
necessary.
additional affidavit?
Not
In a
necessary
appeal-
now. This is a question of fact that
In a appeal,
admitted position, my lord.
Oh, you.
It's already there.
Sir, already there.
It's
Okay,
already
it is
there.
And the
Sometimes I
lordship will
don't
fix it
understand.
on Thursday, my lord,
Confused.
as the first item. Thursday, so that we can finish it.
Thursday is fast item, my lord.
No, no, no.
What heard? First item.
Huh?
My lord is now.
It's
a-
allotted.
I know it's allowed to. be.
Even then, my lord, since
Unfortunately for us.
No, my lord's now a difference and now it seems to be my lord the criminal matters. My lord
that's
is
why I am
very-
saying, my lord, lordship will take up, but we'll make it free, my lord, to your lordship, to take up other matters.
Lordship laugh for criminal matters. Lord.
Have deprived us from placing our case.
Not a question of love, question of where I put that all. So anyway, right, where the parties is the matter on Thursday.
My lord, as first.
Let's not burden the
No, no, no.
registry. Because we see, there'll be, there's a lot of factual issues and we have to go into the records. It's not so easy.
What's clear and clear.
We have to see all that.
I'll present.
You will finish off, maybe in 1-2 hours. Then our job is to see whether what you said is correct. We'll have to juxtapose it with the records.
I'll reduce my. As a list of things, right, Manu, I'll make it number, whatever has happened, Manu, the chronologically.
Basically, we'll have to see.
The resolution.
No, resolutions. We have to see the resolutions. And what are the basis for the resolutions? And of course, now it's a very, I don't know, peculiar manner in appointing a protocol officer if we take your point of view. All along is promotion, then suddenly by,
Only once.
uh,
Thereafter, from 2014 till date,
no, I mean to say, no. Till, can you be directly promoted or appointed to the post of SJA? Or is it a promotional post?
it's a
SJA,
promotional post for from J.
from JA. So JA is the direct entry point,
Then.
correct?
Okay.
Now from SJ, suddenly, unless you are SJ, you cannot be directly appointed as protocol officer. That is your case. Now you think of that in that manner.
Manu, my lord.
You see whether that is,
Why that? Manu?
so we have to see.
My lord, for food for thought.
Hmm.
Why that? My lord will forget the chief secretary's post for the time. Protocol officer, it's a very demanding post.
No, I understand that
Man-
aspect.
No, there is a reason. The man should also be up to that. So you bring it and you keep it. My lord would say, if he comes here, the rules don't provide for any further promotional avenues. It's not there. It's not there. So what would have been in the because it's not there. What would have been in the committee's mind would be that if he is found not up to the mark, we take him back. 1. 2, he is there, but we cannot promote him from that. He'll be isolating there because that's a single category. It's a single category. It's an MCAT post, but it's a single, it's a.
Which
it's a-
one? Which
the
post?
protocol officer. So what?
No,
happened-
not because, but because of 3A, it becomes a promotional post.
No, it's not a promotional post, man. That's what I'm trying to say. 3A, secretary post, it is said that these would be would be the minor portholes from where the
No.
chief justice can go.
Yes, naturally. So what does it
It's
mean?
not a promotion, it's an appointment. It's a
Again,
direct recruitment. Again.
And supposing after secretary, he goes back,
No, he can, my lord, if he's regularized there, it could be a different.
then
Otherwise, he can go to. the
where
next line.
is the question? That then your appointment is to an irregular post or what in the initial stage?
My lord, the posts are permanent.
Let
That
us
is
see.
something which my lord will.
I
have
think
look
we'll have to
into.
let us
No,
say,
no, my lord, if there is something, that is something which my lord will have to look into in the other
in the other,
administration. There are loopholes in our system. I'm not saying it's not there, but everything what we have done, it's bona fide.
no, I'm not saying it's not bona fide, it's bona fide. But
if
whether-
there
whether-
has to be overhauling is now the cases are over. Overhauling of our system is long.
Long due,
Overdue.
overdue, yeah.
Over.
So we'll see. The only thing
This
is
is
that,
not the only instance. This post is not the only instance. There are other factors also. There are other posts also, which requires a raw thing from the in the administration. It requires.
to get the appropriate. person.
67, we are 2003.
no, that way I understand. That way, he might be the most efficient person. That is not the
That's
issue here.
not the thing.
That's not the issue here.
But this process itself.
Whether the High Court suffers any, in their procedure, whether it suffers any lacuna. Or everything is, reasoned, we'll have to see all that. Let us-
If there is a lacuna, but the system is okay, then my lord will not interfere, my lord will be administrative side. will crease out iron out the, my lord, lacuna. But here, I think it's high time, my lord, the other side, it looks into this. Otherwise, these issues will keep on coming.
Yes, okay.
Much-
One item left. Oh, one item left. Okay, one item left. Oh, yes. Oh, we are fixing that too. I forgot.
May I please your lordship,
Yes.
before my senior make the submissions, I would like to point two facts. Your lordship, this matter, they filed for the cancellation of bail, number one. But my lord, there is an analogous writ petition. Writ petition has been filed, which is pending before the Kohima bench, where after the bail was being granted to me, I have challenged the entire proceeding, which is stay order has been there. Your lordship will kindly see the order passed by the division bench in this matter. Dated 14/11/2022.
Where is the order?
14/11/2022,
14/11.
my lord.
Yes.
On the hard, Mr. D.K. Das, Learned Senior Counsel, listed by me. Learned Counsel submits that he has received instruction to appear on behalf of the sole respondent in this case and prays for a week's time to place the Wakalatnama on record. Mr. Burger further submits the connected proceeding of in the form of WPC number 4K18, wherein the supplementary search sheet as well as some other notifications connected with the present proceedings are under challenge and the matter is fixed for final hearing and disposal before the Kohima bench. According to Mr. Burger, the outcome of the said proceeding will have a relevant bearing in the present proceeding and therefore this matter be posted again on first week of December 2022. And subsequently, your lordship, this matter came up on two occasions and it was been pointed out. Now, the second issue is that bearing this Kohima bench matter, similarly situated persons whose bails were being granted by the special court NI in Dimapur, whose orders were being challenged before this court and they have been set aside. Against that order, they have challenged before the Supreme Court. The Honorable Apex Court has set aside the High Court's order. The issue was that whether
What do you want to say?
no, my lord, what I am going to say is that in this matter, till this matter, the Kohima bench matter is decided, which is coming up on 16th of this month. 16th of this matter has to be kept in abeyance. Because it is a writ court proceeding, my lord.
How does it matter? This is with regard to the bail. That is with regard to the whole case in question. That's a different issue.
Not your lordship, then in that case, my lord may permit me to file an short summary of facts in the form of
Why?
affidavit. I will raise these issues, then your lordship can take a call in this matter.
What is there to, what is,
Because my lord-
there are no disputed questions of fact.
My lord, they are saying that the order passed by the special court, which has been passed, they are impugning that order. And in similar orders has been set aside by the Supreme Court, my lord, the High Court's order. That is the main thing.
I think he's very happy.
It's up to him, but.
Yes, it's up to him. You don't know the orders passed by this court, I think.
The High Courts has passed the orders setting aside the bail order granted by the special court.
Subsequent orders passed by this court, you don't know.
But he wants time.
He wants adjournment,
wants
will
time.
adjourn it.
He wants time, but
Yes, right. Mr. S. Burgohain, Learned Counsel for the petition submit that the matter may be kept, the matter may be kept pending till disposal of WPC number 4K/2018. In as much as WPC 4K of 2018 is listed on 1610.
1610.
List the matter.
October, no? But I may, October, 16 October.
1610.
Yes.
1610 is October. This is the matter after 1610.
I'm appealing for appellant matter.
Mr. D.K. Das, Senior Counsel appears for the appellate
I'm taking
along with, okay, assisted by Miss.
G. Chaudhary.
You got. You should have, you should have, dispose of the matter.
But in the morning hours, but I would not come.
My lord,
When I mentioned the matter.
no, you were just saying to me because I know your lordship is similarly situated persons, the matter has been disposed of. Might be very frank, and an officer of the court, since on the last occasion, when the High Court, when this bench was alive that petition is pending, let it keep in abeyance.
We
So-
have, we,
So I put it before your lordship. If-
because these matters have been, similar matters have been disposed of.
My
by-
lord. Let
And
me take a
and we have upheld the order.
My lord.
You don't want it, so what to do?
Yeah, and this appellant, he is a government servant. I was a government servant now.
That is why
I was a.
you're not interested.
No,
in this.
my lord, it is not like that, my lord. Because on the last, that order, since I have to take a chance in the 16th of, after if it is not been proceeded, then I will place before your lordship.
What is the difference? I don't- What is the difference? If you get an order now, I don't know how it will prejudice you. In fact, it's more favorable to you.
Anyway.
That's your problem.
Obliged. Thank you. Thank you. I'm not gonna do again.
So basically allowed, huh? What's up? Him. Allowed, you know. Dismiss. Yes.
Matrices will have been brought.
Yes.
My lords, this is a review petition against my lord's judgment and order dated 11/2/2021.
Yes.
Now, my lords, due to certain misconceptions
Yes.
and due to the fact that certain facts are not placed before the honorable court, an error apparent has crept in the record, my lord. Now, my lord, if I may kindly narrate the background of the matter, my lord.
Yes.
My lord, the review petitioner was the respondent number 6 in the writ petition, my lord. She is Mamuni Kolita Bajbola.
Yes.
Now, my lords, there is a village called Khata Pajipor village in the district of Nalbari, and under that village, my lords, there are 2 Anganwadi centers. Khata Pajipur is the village. There are two Anganwadi centers, Pajipur Poob Anganwadi Center and Parwa Pajipur Anganwadi Center. Now, because of the names, my
No,
lord,
but what did you say? One was?
one is Pajipar or Parwa Pajipar Poob Anganwadi Center and Parwa Pajipar Anganwadi Center.
What about poop? There's no poop.
There's
There's
Poob in one. There's
Huh?
Poob in one. There's Poob in one. Yes, there.
One is poop, one is without poop.
Now, that is the reason why the entire my lord's confusion has arisen, my lord. Now, let us not go with the names, my lord. Let it be A and B, for example.
No, let us go to the advertisement first.
Yes, yes.
Where's the advertisement?
Advertisement, my lord, at page 14.
Page 14, yes,
Page 14 is the advertisement.
yes.
I'll read it out, my lord. The applications are invited from interested female candidates for rendering voluntary services against vacant post of Anganwadi worker. My lord, kindly note vacant post. So since it's a vacant post, it's not a newly created post. So
Okay,
yes,
okay.
vacant post.
No,
It has
look,
to be-
look, please, don't take time. This is a review.
Yes.
If I've got to hear the entire case, it's not going to be an appeal. I have to dismiss it.
Yes,
So you have got to go straight away to the facts.
I'll take 10 minutes only. 10 minutes.
It shouldn't even take 10 actually.
Must-
Because this is a
5 minutes,
review.
okay.
This is a review.
My-
Remember that.
Yes, I'll remember.
You got a very small window.
Yes, yes, yes. So my lords, there are two Anganwadi centers. The advertisement says, my lords, that it's a vacant post and the advertisement says that only candidates who are residents of that particular Anganwadi center can only apply. So
Yes.
that's a settled position, my lords. Now, my lords would come to page 35. Page 35, this is a
No, but it says which Anganwadi center.
yes, yes, my lords. The advertisement did not mention the name of the Anganwadi center.
Okay.
But my lord, with all due respect, as a person aspiring for the post of Anganwadi center, she is presumed to know at least to which Anganwadi center she belongs and where has the vacancy arisen. That must not have been communicated to the learned council, senior council, my lord. Now, my lords would come to page 35 for a moment, my lord. For a moment.
Yes.
The Gaambura certificate, which in the judgment, the writ petitioner, my learned counsel appearing for the writ petitioner himself relies to show that, see, my Anganwadi center is Poob. My lord, page 35 for a moment. Thank you.
Yes.
It has been relied, my lord, the judgment has been, just a moment, my lord. Page 35.
Yes.
Certified that Srimati Mamuni Kolita Bajborwa, wife of so-and-so, 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 is the resident of my area. I know her very well. I wish her success in future life. There are two Anganwadi centers in Khata Pajipur village. The village surveyed into two parts by establishing Anganwadi center in the year 2009. 10. They are Pajipur Anganwadi Center 217 and Parwa Pajipur Anganwadi Center 23. On the basis of the survey, Srimati Songita Haloi Borua, who was the writ petitioner, is included within the area of Pajipur Poob. Anganwadi Center and Mamuni Kolta is included in the area of Parwa Pajipur number 23. Now, this document was relied by my learned senior friend to contain, see, my Anganwadi Center has the name Poob, PUB. That is 217.
Yeah.
Yes. Now let us see where did the vacancy actually arose, my lords. My lord would come to page 37 for a moment, my lord. The copy of the Anganwadi survey reports, center reports. Page 37 for a moment, my lord. Lordship has it, my lord. Page
Yes.
37. My lord would see this is Pajipar is, this is the center number is 217. The third column, first, second, third, fourth, fifth, sixth row, my lords,
Yeah.
217.
Yeah.
Center number is 217. Now, my lord would see the Anganwadi worker. Name of the Anganwadi worker is there.
Hmm.
Podumi Bajborwa. And Anganwadi helper is Monju Bajborwa.
Hmm.
Now, my lord would come to page 39. Page 39.
Yes.
Songita Haloi Borwa.
Yes.
She is a resident of 217 Anganwadi Center, my lords, who is the writ petitioner.
How do you get that?
But it's written, my lords, the same. I have the translated copies are there. It's the one survey report. Is the Anganwadi Center 217. I gave the names, my lord.
No, no, page 39, where does it say that she's from 217?
My lord, 37 is the first page and rest are continuation, all the residents. 37 I've showed it, my lord.
Okay, so who are these persons at 38 and 39? They are the applicants or what?
38 is Podumi Bejborwa, who is the Anganwadi worker in 217. Anganwadi worker in 217, meaning thereby that 217, the post of Anganwadi worker was never vacant so as to advertise the same. I'll prove it further, my lord. My lord will see next. Page 45 for a moment, my lord. I won't take much time, my lord. Try to be as fast as possible, my lord. Page 45.
Yeah.
Page 45, Podumi Bora Manju Bajura, page and thereafter, my lord, page 49 and 49.
45 and 30,
Same, my lord.
huh?
49, my lord would come to page 49. Page 49, my lord is there, my lord.
Yes, page 49.
Page 49. My lord, the first date of tabulation that has been wrongly typed, the actual date is 8th of January 2020. Lordship can find it out from the vernacular, my lord. I'll show it to my learned senior friend.
Yeah.
The vernacular is also there in the 8th January 2020. My lord would see at number 2, Srimati Podumi Bejborwa.
So what does it show?
It shows, my lord, that the post of Anganwadi worker in Anganwadi center number 217 was never vacant, so to advertise the same. my
No,
lord.
but this page 49 does not say that it pertains to 217.
My
Where
lord,
where does it show?
it is the continuation of, I have given the type copies, my lord. The original, my lord, the page. Just a moment, my lord. Page 54, page, page,
These are the same arguments which are there before one law in the writ petition. Nothing new.
my
That
lord,
was already
my
considered.
lord, can you let, page 54 is the vernacular, my lord. Now, my lord, I'll just refer to another document, my lord. My lord would come to page 64. Page 64, my lord.
Are these documents a part of your writ petition?
Affidavit in opposition.
Affidavit?
This is not part of the, this is produced.
Affidavit in opposition.
Huh?
No, my lord.
Affidavit in
No,
opposition.
no, my lord. No,
I have it with me, my lord.
well, I prepared my case, my lord. I know it's not.
This is the one.
My lord, kindly peruse, my lord, page 54, 64 for a moment.
Page
It
30,
is
my lord.
very clear, my lord.
Page 30.
Nice amount. It's not there, my lord.
Some documents are here, some documents are not there.
The document which I'm referring right now, my lord, page
Page
64.
64, give it back.
That will make the things very clear, my lord. Page 64 for a moment.
Yes,
My lords, the first column is name of AWW, that is the Anganwadi worker, stroke AWH, the Anganwadi helper. The third column is the code of the Anganwadi center. And the second is the name of the village, my lord. At serial number 13, my lord has it,
Yes.
the third column, Onima Bajborwa, Kanika Deka. So Onima Bajborwa was the Anganwadi worker and Konika Deka was the Anganwadi helper. Next, the name of the village and next the name of the center, 23. My lord has it, 23?
23.
Yes,
Well,
that's
what
the
do you mean?
name of the center. The third column, my lord's code.
But then it should be, okay, 23.
Yes,
But
that
then,
is the center to which the review petitioner belongs, 23. That's an admitted fact because my learned senior friend has relied on that Kampura certificate to contain that this is correct. My lord, 23 is the third column. My lord has it code,
yes,
code. The third column, third row, 23. Now, Lordship would kindly see the date, my lord, 2014 above at the top. This data is of 2014. Correct, my lord? 2014.
where, 2014,
My
yes.
lordship would now turn the page, kindly, my lords. And have a look at serial number 28 for a moment, kindly.
Yes.
28 is Podumi Bajborwa
Ah.
and Monju Bajborwa. The code 217,
Yes,
and I have shown from the other documents that till 2020, Podumi Bajborwa was alive. The advertisement was of 2019. Now, my lord would come to the death certificate of Onima.
no, but then out here also Pasipur Poop, it is.
Yes,
given.
yes, my lord. That's
And the other one also is Poop, both,
my lord.
13 also is Poop.
That's all. Reminds me of Romeo and Juliet. What's there in a name? My lordship will not refer to the name at all. It is the center because the vacancy arose against the center, and it is only the members
A
of the
vacancy arose against which center? 23.
23. That's what I'm trying to show, my lord. If that is the case, and admittedly the writ petitioner was a resident of 217, then she could not have been appointed to 23. Now, my lords, have seen, I have shown what I'm trying to my analogy, my lords. It may sound a little bit complicated, but otherwise, my lord, if I'm not being able to explain myself very properly, my lord, there were two centers, 217 and 23. The advertisement was for a vacant post. That vacancy arose in 23 due to the death of Anima Hazarika, whose death certificate is appended herewith. And it could not have been for 217 because that Podumi Bajborwa, who's already working as the Anganwadi worker appointed in 2014, data shows 2000, she's still alive and she's working as the Anganwadi worker. So now, since the vacancy had arisen in 23, her application was rightly rejected. That was rejected because you belong to your residence is outside the
217.
AWC area. It's in 217, it's not 23. Now that should have been communicated to the learned senior friend, my lord, because a person who's aspiring in a village, who's aspiring to be a Anganwadi worker, at least there's one presumption that she knows to which Anganwadi center she belongs and she knows what is the vacancy, my lord.
No, not exactly. There are many cases where outsiders have participated.
Now, this is not the case of an outsider, my lord. Here clearly now, my lord, would come to just for a moment, my lord, to fortify my arguments, my lord. Lordship would come to
This is basically an appeal. You go and appeal. I think.
no, my lord, because this is because of a misconception and because of certain, my lord, if lordship had not gone by the name and had gone by the center numbers, this error could not have been there, my lord. Now this is an error apparent on the face of record because someone was not.
I don't find it.
My lord, we'll have page 32, I think that.
My lord, last
Page
before,
32 of my lord's order.
before I lordship kindly take up 67 for a moment. The death certificate of Onima. Late Shrimati Onima Hazarika was
67.
page 67, my lord.
Yes.
The second paragraph. Late Shrimati Onima Bajborwa, who was working as Anganwadi worker in 23 number so-and-so, Parwa Pajibur Anganwadi Center, number so-and-so, passed away on 30/9/2017. Until the time of her death, she was working in the said Anganwadi Center. She passed away in 2017 and hence in 2019, advertisement was issued to fill up that vacant post in 23. Now, admittedly, it cannot be denied now that the writ petitioner is a member of 217. because that has been admitted in the judgment. They have relied on the Gaobura certificate, where the Gaobura has said that she belongs to Pajia, Pub, that Anganwadi center, which is 217, and I belong to 23. Now in 217, the incumbent Anganwadi worker is still alive and still working, appointed since 2014. So the question does not, I've shown it from the documents. The question does not arise that there was a vacancy in 217 and she has been appointed in 217. Now just one query from your lordships and everything would be clear. If your lordship directs, if your lordship is not satisfied just in case with the document, the lordship may just ask one query, pose one query to the Panchayat department, whether which Anganwadi center the vacancy arose. Everything
lord.
would be clear.
Page 32, madam.
Apparently, my lord, it was not communicated, my lord. She knew that she was a member of 2 and she was rightly rejected therefore. That you are outside the center area.
My lord will have page 32, just for what my friend is trying to say. It's nothing new. It was the argument which they developed. And my lord will have the writ petition for a second.
Give me the.
Two page marks I have done. It's there in the review petition also.
Yes.
My lord, 2 page marks.
Yes.
First is, my lord, the list of applicants.
Yes.
My lord will see serial number 4 down.
Yes.
Paurapara, Pajipur, Pup side.
Yes.
My lord has got it.
Yes.
Then my lord will see the next flag. That is an application submitted by me.
Yes.
Receipt of an application. That is, my lord, I think my lord is having the vernacular. The
Yes.
original would be just 1 page ahead. Before, sorry.
Yes.
Applicant's name, Sangita Haloy Borua. Center's name, Paurapar, Pajipur, Pup. And the vernacular one is more clear. Madam. And my lord would have page 32 again.
32, 33.
My lord, my lord's the review petition, my lord's order,
Okay.
32. My lord, second paragraph.
Yes.
Mr. So-and-so, learned counsel for the respondent on the hazard submits that the vacant post of so-and-so was to be filled up in respect of Anganwadi center number so-and-so, that is Parvatpur so-and-so, so-and-so. He submits that the advertised post was to be filled up was in relation to Anganwadi center number 23 and not in relation to Parvatpur, Pajipur, Pup, Anganwadi 217. As the petitioner is not a resident of so-and-so, there was no infirmity in the decision of the state of respondents. Now, my lord will see the government stand. Third paragraph. D. Nath, learned counsel for the state respondent, submits that as per official records, which he has brought today. Page 32.
Yes.
Mr. D. Nath, learned counsel for the state respondent, submits that as per official records, which he has brought today, the advertisement for filling up the vacant post was in relation to Paurapar, Pajipur, Pup, Anganwadi center, and there is no Anganwadi number mentioned in the advertisement. He also submits that the application submitted by the petitioner and the respondent number 6 is for appointment to vacant post of Anganwadi worker in Paurapar, Pajipur, Pup. Submits that the petitioner was not selected by so-and-so and she was so-and-so, so-and-so. Then my lord would have the next page, the third paragraph.
Yes.
The official records are perused and is seen that advertisement has been issued for filling up the vacant post of Anganwadi worker in so-and-so and not for filling up the post of Anganwadi worker in so-and-so. There is no number reflected in the advertisement either as 23 or 2017 against the so-and-so. The list of vacant posts under so-and-so which has been made by the child development officer on so-and-so shows that the vacancy in respect of Paurapur, Pajipur, Pup, Anganwadi center. The application submitted by the petition, the respondent number 6 is for the Anganwadi worker in so-and-so. The comparative statement or selection of so-and-so shows that in respect of so-and-so, the respondent number 6 has been selected. Now, my lord would see my appointment. After your lordship's order, her appointment was interfered with. And my lord interfered with her appointment. I was appointed. My lord will have the appointment order. The appointment order says, I have given both vernacular as well as the thing. Mamuni Kalita Besboro Anganwadi worker of Paurapar, Pajipur, Pup, Anganwadi center. Then my lord would come down. Third paragraph. She was removed.
Mamuni is the.
Is the my lord who was
Writ
the
petitioner.
writ petitioner. No,
No,
the review petitioner. Respondent number 6. She was removed from Paurapar, Pajipur, Pup, Anganwadi center. And third paragraph. Say Sangita Borua, so and so, you are hereby informed so and so, you are allowed to render honorary service as Anganwadi worker at Parwapar, Pajipur, Puk, Anganwadi Center. My lord, in the advertisement, my lord found Puk, in the list that was prepared, Puk, application submitted for Puk, and when the removal order came, that is also for Puk. And my appointment order is also for Puk.
That is the reason why I started, my lords. Name is inconsequential, my lords. That what you call a rose will still.
Because
tell
the
same, my
government never went by the numbers, my lord,
Lordship
went
would
by
just,
the.
just make one query. Whether, my lord, that thing was never well clarified. Now, that is an admitted fact. She belongs to 217, and there's no vacancy in 217. Now, my learned senior would clarify that
How
position,
come
my
I
lord.
appointed, my lord? I have been
My
appointed.
learned
drawing
senior
this
friend
as-
is referring to the names, my lord. That's what I'm saying. That's how, why the confusion arose, my lord. It's not about the names. There are Anganwadi center numbers, and only residents of those centers can be appointed. Now, it is clear from the records, my lord, that 23 vacancy arose. I was a resident of 23. I applied. She also applied. She was rejected because she was not a resident of 23. Thereafter, her appointment, of course, my lord, it's a mandamus by the court. She has to be appointed. Now, it will be perpetuating an illegality, my lord. Let my
My lord,
learned
these
senior.
were the same arguments
Let
which
my
were
learned,
there.
I was not there, first of all, my lord.
Maybe, my lord, but these
That
were the
was the
same.
case.
arguments.
These are the same.
Same
things that are
argument
taken up
made,
if
my
you-
lord.
No, my
if
lord,
you
My lord has noted it.
These documents were not placed. These documents were never placed. Now, my lord,
Now you can go in appeal now.
That's it.
no, my lord,
Uh,
if I may kindly try to satisfy your
No,
lordship.
I think review. there's
My lord,
very
just
limited-
build a
We'll
short
expand
judgment.
that.
And I didn't even get the entire judgment, only the, my lord, head notes, my lord, just to save time, money. Kindly,
No,
my
no, I
lord,
think we have heard you for half an hour already.
just 2-3 lines.
Review cannot partake the character of an appeal.
No, my lord, because here, what the Supreme Court has to say, yes, what I believe, my lord, I'll be satisfied with your lordship. Kindly.
Okay, only we'll hear this. We'll just take, yes, fair.
My lord, number, it starts as a section 114, order 47, starting, my lord. Review. Grounds
Yeah.
for expression mistake, sufficient reason, scope. Mistake, hell covered mistake on the part of the court regarding the nature of undertaking given by a counsel of a party. What constitutes sufficient reason? Hell would depend on the facts and circumstances of the case. Words sufficient reason, even a misconception of fact or law by the court or even an advocate. Moreover, the doctrine of actus curiae neminem gravabe also may necessitate a review. Now, my lord, if it's a mistake, let it be on the part of the council or the court or a misconception. Now, that misconception is clear, my lord, in my humble submission, my lord. Now, if that is addressed, I don't have a case. If my learned senior friend argues that no, I am a resident of 23, then I have no case because she scored more than me. That is an admitted fact. In
No,
the,
you see, now take the other way around.
my lord.
If you say that she was not a resident of 23, but of 217, then in that case, your client could not have been a resident of 217. He was of 23. That's your case.
I'm 23 years. Yes.
That's what.
And vacancy arose in 23. That's why I applied. And I got appointed. And she scored more than me and she was not appointed because she was not a resident of 223. That is the simple case, my
But
lord.
the documents reveal that everything.
My lord,
was for
again,
Puk.
my lord, not fall into the trap of names, my lord.
No, I'm not of that.
Pajipur.
Because
Let
that was the
let my
argument.
senior
My lord
friend
did not
argue on
expect
the
the
center
scope
number.
of the, my lord, review, because that was the very argument which was there before your lordship.
Now, when I pointed it out that it was erroneous, this argument won't do that I had argued the same thing. At that
Yes.
point of time, these documents were never placed. I
And
did
my
not
lord,
place
see
the
the
death
subsequent
certificate,
action.
of the,
How could have they appointed me?
let there be some
in
argument
Puk,
on
but
merits,
that
my lord.
She has not even counted. She has that removal letter. She should have said that that thing is wrong.
Okay, that poop, like you have been removed from this poop.
Yes.
Puk.
This poop, Parava Pajipur poop.
Uh,
Now, according to you,
she's
this Parava Pajipur poop is 217. It's,
No,
it's 23.
Because the
But
names,
then that.
because the names are so confusing.
No,
Sometimes it
no,
is
but then-
Parva Pajipur,
but then-
sometimes it is Parva Pajipur.
Clarify.
No, my lord. See, in the same village, see, my lord, that is the reason the name of the village itself is Khata Pajipur village. That is the village. Now, one Anganwadi center is Parwa Pajipur Anganwadi center. Another is Pajipur Poob Anganwadi. There are two Anganwadi centers. Now, if your lordship makes a query, a simple query, my lord, addressed to the respondents, that to which Anganwadi center the vacancy actually arose.
This order is there, then you challenge this.
No, well,
This order is there, this order says. Mamoni, Kalita, so,
Yes.
Parawa, Pajipur, Pup.
And she has not even brought
That-
this to the notice of the.
That was the thing, my lord, because of the name.
No, that's not the authority.
See, I have made a mistake, authorities have made a mistake, only you are the one who has not made a mistake.
No, I made a mistake, my lord. I always agree, my lord. There was
No,
some
no,
mistake.
no, no.
I should have produced these documents before, my lord.
Anyway, right, I think.
Just one query would lordship
no,
make, my lord.
No, no.
Kindly,
I- You can go in appeal. This, as it is, it's so confusing to me, these names. Somehow I managed to write the order. After going through the records and, checking up the numbers, everything. And not only that, the government had made a submission, you had made a submission, maybe not you, but your
Somebody did.
predecessor. So I don't think anything remains.
just one query next time, lordship would fix a date
No,
after,
no.
after puja.
I
my
think
lord.
we have given enough time to you.
After puja, just.
No, no. Heard. Yes. Heard. Mr. Mr.
P. Mohantam.
P. Mahanta, learned counsel for the review petitioner. Also heard Mr. UK Nair, learned
Yes.
senior counsel for
Opposite party number one, by the way.
opposite party number one. Mr. Ardhar for respondent number
2, 3, 4, 5, and 6.
2, 3, 4,
to 6.
5, and 6. Good stuff. The review petitioner's case is that a mistake has occurred in the impugned order dated 11/2/2021, passed in WPC 3023/2020. Inasmuch as this court had decided the case on the basis of a vacancy that had occurred in Parawa Pazipar Anganwadi Center. Which was covered by number, which had the number 217. Pustam. However, this court had decided the issue by considering the vacancy to be that of Parawa Pazipar Pub Side Anganwadi Center.
So, wait, 1723, my lord.
Number 23, covered by number 23.
Before that, my lord, 217, my lord, has used. It should be 20.
217 will be with regard to Parawa Pazipar Anganwadi Center. Pub is
Pub.
23.
Hoop is 217, other one
Acha.
is 23.
Acha.
If
Who
Pub
is-
is 23, my lord, if my lord is holding that.
Pub is
217.
217. Okay, Pub is 217.
217.
Pub is 217. And Parawa Pazipar Anganwadi Center is number 223. Yes, correct. He made a mistake.
I am not getting it, but 23.
Ah. Good stuff. The learned review petitioner submits that in terms of the documents in the review petition, the vacancy that occurred was in respect of number 23 Parawa Pazipar Anganwadi Center. And not in respect of number 217 Parawa Pazipar Pub site Anganwadi Center. It's a pub and one is without pub, okay? So, he submits that the confusion in the they submit that that confusion with regard to the vacant post had occurred as this court had decided the issue on the basis of the names of the Anganwadi Center, without going into the fact that the vacancies should have been considered on the basis of the numbers provided to the Anganwadi Center. Next, Mr. You can, the learned senior counsel for the respondent number, opposite party number one, submits that the issues raised by the review petitioner had already been decided in the impugned order dated 11/2/2021. Wherein which was clarified by the official records which had been produced in the court. He submits that the fact that there was a vacancy in Parowar, Pajipur, Pub, Anganwadi Center is clarified, is supported by the order dated 14/6/2021 passed by the Office of the Child Development Project Officer, Nalbari Integrated Nalbari, Government of Assam, wherein the review petitioner has been released from her post as Anganwadi worker of Parowar, Pajipur, Pub Anganwadi Center. And the writ petitioner has been appointed to the said place in her place.
Just one point that was, so page 64, both the Anganwadi center has the name Poob in it, madam. That is the page 64. 64 for a moment. How can that be a mistake? It's against my learned singer. It's a mistake. Page 64, my lord. 13, this 23, it's called Parwa Pajipur Poob Pordoitola. Lordship would turn the page. 217 Pajipur Poob side. On the next page, that's serial number 28.
But Mano, in the other documents provided, 217
That
is
is the reason, my
Pajipur.
lord. That is the reason why Poob has
Mano will not even go into this. This is only to create a confusion.
create a confusion. This is not a document manufactured by me, my lord. It's a document project and Anganwadi center-wise baseline data. How can I create confusion? It's not my representation, my lord, or a
Mano
letter.
will have the certificate at page 35. His
That is the
certificate, he's
reason, my lord,
relying,
the confusion arose.
he's relying on.
And that is why I'm
Pura.
saying, lordship, the name should be followed, the number should be followed, my lord.
One is Corridor Tala and one is
The Mano, the page 35.
My lord, see the
And the
village,
pleaded
both
cases-
is the same village, both are in the same village.
Mano will have page 35, man.
Parwa
His
Pajipur
certificate.
Poop and Pajipur Poop side.
This is the, my lord, certificate he is relying. Page 35. There are
Yes.
two Anganwadi
Yes.
centers in Kat Pajapur. The village surveyed is into two parts by establishing a HMS so and so. They are Pajipur Anganwadi Center number 217 and Pajipur Parwapar Pajipur Anganwadi Center number 23. They have not put poop there. On the survey
That's the
so and so
That's the
217 and Mamuni Kolita is 2123.
That is
And
the
mother,
confusion,
father, my lord, in the affidavit that stand is very clear, my lord. That is, my lord has recorded that in paragraph, in the last paragraph at page 32.
Since there is confusion with regard to the names, and that
Full
is the
stop.
reason why
Next. Whatever.
I'm insisting, my lords, that the number should be followed.
Next para. Mr. R. Dhar, learned counsel for the state respondents, submits that there is no infirmity with the impugned order dated 11/2/2021 as the vacancy had occurred in the post of Anganwadi worker in the Parawa Pazipar Pub Anganwadi Center. I have heard the learned counsel for the parties. The impugned order dated 11/2/2021, passed in WPC 3023/2020. Had considered the submissions made by the review petitioners council had considered the submission of the review petitioner, who was respondent number 6, and had also no, this is point number 6. Full stop. The extract of the order dated 11/2/2021, passed in WPC to 3023/2020, is reproduced below. Just again, I put it in red, huh? Para 30, page 32 and 33. Just take from here to full stop. Next paragraph. This court had disposed of, no, this court in its order dated 11/2/2021, passed in WPC 3023/2020, had held that the writ petitioner should have been appointed to the post of Anganwadi worker in respect of Parawa Pazipar Pub Anganwadi Center. And consequently, the appointment order issued in favor of the review petitioner was set aside. Full stop. The state respondents have issued the order dated 14/6/2021, releasing the review petitioner from service as Anganwadi worker and appointing the writ petitioner to Parawa Pajipur Pub Anganwadi Center. Full stop. This court is of the view that in view of the fact that there is no dispute, this is of the view that that in view of the above facts, no case for review has been made out. Full stop. Further, in the case of state of West Bengal versus V. Kamal Sen Gupta, reported in 2008, 8 SCC 612, the Supreme Court has held that review cannot partake the character of an appeal. That is the matter. This court does not find any grounds to interfere in the review order. The same is accordingly, the review petitions accordingly dismissed.
Malot, there are some things from there, nothing to do with the case, madam. After this order was passed, the lady was appointed, 2 small kids, madam. The husband passed away in COVID.
Oh,
This is God's, madam, maybe.
okay.
DPO like mine.
Deeply over.
You go, you send someone, you send Nilakshi. Call Nilakshi, stand up.
May please your lordship, my lord, by order dated 9/5/2023, the report was on instruction was asked for, my lord, whether the post of Anganwadi worker had been filled up or not in terms of advertisement. 1/8.
8/2/19.
Yes, my lord.
Yes, Mr. Dar.
I have instruction, madam.
Yes. Have you got the instruction?
আপোনাৰ টাইমৰ নাম কি আছিলে? তোমাৰ নামটো আছিলে বানু বেগম। সাহাৰা বানু বেগম। অভিজিৎ পাৰ্টি ৰুণা লাইলা নেকি? অভিজিৎ পাৰ্টি নাই, তাকতো পাৰ্টি কৰা নাই। তাৰ নাম কি আছিলে? ৰুণা লাইলা? No party. No. No one has been made party. আগত কিবা আছিল নেকি? ৰুণা লাইলা পাৰ্টি কৰা হৈছে। No private party. Yes, my lord. I'm just getting this instruction. It's in one Runa Laila. Person to the order. The instruction was asked for whether the post has been filled up or
Fill up, that's all. So what is so difficult to answer?
no, my lord. Someone has appointed. Runa Laila. The appointment order. Particular.
Oh,
Someone is appointed.
so someone has been appointed.
My lord. Then the next page. That is why I was trying to. My lord. In that case, my lord, I think, my lord, that person is to be made party in the case. My lord. So, my lord, her address is required to make her party. I may be given a person to make her party, my lord.
You will have to challenge that. You'll have to make amendment of the writ petition.
Yes, my lord.
Then you'll have to
Challenge is appointment time.
challenge that appointment,
So, my lord, then, my lord, we may be given an opportunity
withdraw.
to file a fresh
Right.
one with withdrawing.
I
this.
think better.
Better.
Otherwise, you'll have to file application for
Yes,
amendment.
ma'am.
with no objection.
And my lord, a dismissal of the earlier, my lord, case has not be barred to proceed, my lord.
That is not, that is,
Must.
that orders there, you can always
File.
put it.
Yes, my lord.
All right. Mr. A.R. Sikdar appears for the petitioner and submits that in view of the letter number DWCD bracket ICDS bracket closed E slash 127/2019/316 dated 17/8/2022 issued by the Director, Women and Child Development, informing the Child Development Project Officer, Mattia ICDS Project, Golpara, that Srimati Runa Laila, RUNA, LAILA, wife of Samsul Haq, has been approved for the post of Anganwadi worker at 174 number Bahatichar, BAHA TICHAR, Batipara, BHATIPARA, in terms of the order dated 8/3/22, passed in WPC 1353/2019 and WPC 5090/2017. He would like to make a challenge. To the appointment of Srimati Runa Laila. The earlier writ petition disposed of because of that.
My lord, that has been subsequently, 5090 was restored, my lord.
Then you'll have to again challenge everything.
My lord.
Remember. Full stop. What have I said? Just read. So you'd like to make a challenge to the said letter and consequential appointment order of Srimati. So-and-so, so. He submits that the order dated 8/3/2022 passed in WPC 1353/2019 has been recalled, isn't it?
My lord, yes, my lord, 5090 has been recalled.
No, order dated 8/3/22.
8320. 8320, yes, my lord. By that common order, two writ petitions were dismissed for default and both the writ petitions were restored, my lord. In my review petition, lordship will find annexer 2 and 3. The restoration order.
Eight three two three passed in WPC 1353. Just a minute.
1353, my lord, GLS 5090/2017. That order was
No, where is the recall of the order in
Yes,
one
my lord.
three five three?
recalling order, lordship will find page 19.
Page 19 is
Page
different.
19 is IA civil 20.
This is only with regard to 5090.
My lord, there is also subsequent order, my lord, annexer 3.
Okay. What have I said? Has been recalled. And WPC 1353/2019 has been restored to file. So similarly, the order dated 8/3/2022 passed in WPC 5090/2017 has been recalled and the writ petition has been restored to file. What has happened to those two cases?
My lord, nothing has been finalized, my lord.
They are pending.
Then those matters are tagged to this case, my lord. I can give one. I think 3 and 4, I think. 3 and 4. 3 and 4. Three and 4.
Okay. So stop. Mr. R. Dhar appears for the state respondents. On considering the fact that the approval for appointment to the post of Anganwadi worker to Srimati Runa Laila has been made due to dismissal of WPC 1353 of 2019 and WPC 5090 of 2019 comma, which had been subsequently restored to file, comma. The prayer of the petitioner is allowed. Full stop. Accordingly, the petition, the writ petitions are dismissed as withdrawn, with liberty being given to challenge the appointment of the approval for appointment given to Srimati Runa Laila as permitted in law. As permitted in law. The writ petitions accordingly, that's all.
These two,
Huh?
these two petitions.
Three writ petitions.
My lord, one is review, my lord.
Oh,
There is one review, my lord, review petition number 153. That was, my lord,
what is this
For-
review for?
for seeking review of the order passed in WPC number 4773 of 2020.
For what? What is
My
the
lord,
order?
that was filed because during the pendency of those earlier two writ petition, there was another termination order. And there has been subsequent filing of this petition. While the
Where is the order challenge here?
my lord, we have sought modification of the order dismissing the writ petition, my lord. In WPC number 4773 of 2020, annexure 4, my lord. In my
Page,
review,
page.
24, my lord. There has been a termination order. and,
Whose termination order?
My lord, that is one termination order dated 33/2019. Challenging termination order, this writ petition 4773 was filed. And this, and your lordship has rejected this petition because the
Earlier to writ petition.
earlier two writ petition was dismissed for default and there was a restoration. All these facts are suppressed. That was the reason of my lord dismissing that petition. So we may be given liberty to challenge that termination order also. That part we want, my lord. That the dismissal of that.
Okay, you're right. The Mr. Ardhar also submits. But then this, we have to allow the review petition first.
Yes, my lord.
Then this order cannot be passed here. Okay, then you keep that aside, just make a fresh one. Heard Mr. Ardhar, learned counsel for the review petitioner. And heard Mr.
Yes, Sikdar.
A.R. Sikdar, learned counsel for the petition, and Mr. Ardhar, learned counsel for the state respondents. The review petitioner has paid for setting aside the order dated 27/7/22, passed in, dismissing WPC 4773/2022 on the ground that WPC 4773/22 had been dismissed due to the WPC 1353 of 2019 and WPC 5090 of 2019. 17. What's up? He submits that in view of WPC number 1353/2019 and WPC 5090/2017, having been restored to file. By order dated 27/7/22. 27/7/22, passed in IA Civil 2008/2022 and order dated 27/7/22, passed in IA Civil 2010/22, comma. The basis for dismissing WPC number 4773/2022 does not exist any longer. System. Mr. Ardhar, learned counsel for the state respondents, submits that in view of WPC 1353/2019 and WPC 5090/2017 having been restored to file, comma, the impugned order dismissing WPC submits that WPC 4773/2022 would have to be restored to file. Correct. That is because the very purpose is gone. On considering the submissions made by the counsel for the parties and perusing the orders by which WPC 1353/2019 and WPC, what is this? And WPC and WPC 5090/2017. What have I said? Had been dismissed and subsequently restored to file. Comma. This court is also of the view that the basis for dismissing WPC 4773/2022 by the impugned order dated 27/7/22 does not survive. So accordingly, the impugned order dated 27/7/22 passed in WPC 4773/2022 is set aside, is recalled, and WPC 4773/2022 is restored to file. But there were two review petitions.
One review petition, not two.
What is this other review?
Clear one rate petition with a liberty withdrawal.
That was improvement.
Okay. So out here, so this has to be now, this has to be again, production list will have to be made for 4773.
My lord, a review petition 137/2022 was filed with same prayer, but there was some
Withdrawn with liberty.
My lord, we have withdrawn it,
So now,
liberty.
since we have already restored 4773. Since we have restored 4773. Now 4773 will have to be production list will have to be made. We make a production list for today. Today, we will dispose of all cases. Because it is restored to file. Okay. Production list means cause list, another cause list will have to be made, and we'll dispose it of. You got it, no? Yeah. So stop, next paragraph, next order. Yeah, yeah. Mail section for production list for today. They can make it later on also, not now. The production because it is restored to file and we're disposing of it. Next, you're right. Heard Mr. R. Dar, no, Mr. A.R. Sikdar, learned counsel for the petitioners in WPC 473/2022, WPC 5090/2017 and 1353/2019 for the petitioner, one petition. Also heard Mr. R. Dhar, learned counsel for the state respondent. Mr. R. Dhar, learned counsel for the state respondents, has submitted letter dated 8/7/22 showing that Srimati Runa Laila, wife of just 8/7/22 and 17/8/22, two letters. Okay. Showing that Srimati Runa Laila, wife of Samsul Haq, has been selected
Appointed,
for the post of Anganwadi work.
appointed, appointed also.
For post of for this has been selected and approved for the post of Anganwadi worker at 174 number Bahatichar Batipara in terms of the order dated 8/3/22 passed in WPC 1353/2019 and WPC 5090/2017. Mr. R. Dar submits that appointment order has also been issued to the said Srimati Runa Laila. Next para. Mr. R. A.R. Sikdar, learned counsel for the petitioner, prays that he may be allowed to withdraw the above read petition with liberty to challenge the selection and appointment of Srimati Runa Laila as Anganwadi worker of 174 number Bahatichar Batipara AWC.
Why don't we keep this instruction?
Yes. Next para, you're right. This court finds that WPC 1353/2019 and WPC 5090/2017 had been dismissed by order dated 8/3/2022. However, by orders dated 27/7/22 passed in IA Civil 2010/22 and IA 2008/22, the orders dated 8/3/22 dismissing WPC 5090/2017 and WPC 1353/2019 had been recalled and the two writ petitions restored to file. As such, while the issue of the as such, the petitioner hearing had challenged as such, the petitioner's challenge to a termination from service as Anganwadi worker from 174 Bhatyachar Bhatipara Anganwadi Center was still pending in this court. in view of the above reason, comma, the prayer made by the petitioner to challenge the selection and approval, selection and appointment of Runa Laila, Srimati Runa Laila.
And termination order.
And her termination order of the is allowed. Provided the same is as per law, provided the same is as per law. Full stop. Consequently, the above three writ petitions are dismissed as withdrawn, comma, with liberty as paid. With liberty being given to file a fresh writ petition as per law.
My lord will.
The instructions given to the instructions dated 16/5/2023 given to the government, the junior government advocate, showing the selection and appointment of Srimati Runa Laila is made a part of the record and marked here too as an X collectively.
My lord, the petitioner may be given in liberty to collect a certified copy of the annex.
You photocopy it with your phone just
Yes,
now, you take a photograph.
My lord.
Then you can print it out. No problem. You let him take photograph and you can print it out. है ना? So that the production list has to be made for today, for that 4773. All are disposal. Will be produced today because it is restored to 5 and this and disposed of. Okay. So one additional cost is has to be.
Restored and also disposable, everybody.
Basically heard, you just for yes. Because there's no point wasting time.
Develop.
That's all.
আচ্ছা এই ইনস্ট্রাকশনাল পার্ট 2 আমার কেন ফটোকপি লগে দিছে কে লইলো Yeah, well,